so good when the lights all glow. Is your bargain bin Santa live from the nut show? I got my Velcro shoes and my dollar store hat, a short bus scholar with a mic and a chair. Yeah. It started with a stream and a half-broke cam. Now we're decking out the chaos like a nutty telegram. You showed up anyway, don't know what went wrong. Now you're stuck in the circus singing Shizzy's song. Mine's in the trenches with a wrench in hand, yeeting bots to the shadow band land. While I'm reading court docs like a bedtime tale, y'all still here riding the soft brand slate affair. So here's my Christmas card wrapped in duct tape pride. From the window liquor host to the nut crew worldwide. Merry Christmas to my chat, yeah, you beautiful weirdos. From the lurkers in the back to the day one heroes, to the mods who keep this busted sled on track. You're the reason this nut shack keeps coming back. If you're here for the drama, you're here for the laughs. You're my holiday miracle, my off-label stash. So raise a glass of whatever you got in that cup. Merry Christmas from the fool who never shuts up. Some of you pop in just to say, hey, shit, you're nuts. Then you stay 3 hours while I roast legal sluts. You tolerate my tangents and my bargain brand takes. Still type up in the chat when the internet breaks. My eyes play whack-a-mole when the trolls roll through. Finger on the trigger like not today, dude. Every time I was wrapped like a little red bow. Happy holidays, jackass, enjoy the shit show. So if you ever hit like, or you've ever hit send, you're officially part of this badly wrapped friend. Merry Christmas to my chat, yeah, you beautiful weirdos. From the lurkers in the back to the day one heroes, to the mods with sore thumbs and eyes bloodshot, guarding this clown car like a North Pole outpost lot. If you're laughing at the screen or just shaking your head, you're the reason Santa let me stream instead. So grab a cookie and a seat, don't care if it's stale. Merry Christmas from the nut who refused to bail. About the helmet and the buzzing low gear, but you carry this channel through a wild ass year. Through the late night rants and the 10-hour runs, through receipts, bankrupt clowns, and the missing brain cells funds. If there's any kind of magic in this janky little show, it's you in the chat making this dumpster glow. So here's to the replays, the sorry came late, the ones watching quiet while folding their plate, the members, the gifters, the broke but still here. You paid in attention, that's premium cheer. And Marge my L's with the nerves of steel. You keep the sleigh upright on a ball spare wheel. When I say something spicy and the room gets hot, you're already 2 steps ahead of the plot. If I had a fancy speech, I'd still mess it up. So I'll just raise this lukewarm coffee cup. Merry Christmas. From the chaos connoisseurs to the quiet heroes, to the moms who mop up every digital fight, you're my dysfunctional, delightful Christmas light. If you laugh, face palm, or yelled at the screen, you're carved in the lore of this busted machine. So from my nut shack card to your rented device, Merry Christmas, you maniac. Thanks for being this nice. When the stream goes dark and the screen goes black, just know this nutcase is still coming back. You kept me afloat while I tripped on my shelf. Like, how did this work? Who let him stream by himself? So have a warm, loud, slightly unhinged night. May your drinks be strong and your drama stay light. And from your helmet wearing host on this Christmas delight. Merry Christmas, my people. Now go eat and go have a beautiful night.
Hey everybody, how you doing this evening? Man, oh man, oh man, early mug raid. Welcome, 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 welcome. Ah, Merry Christmas. Yes, it is. It is right around the corner. It'll be here before you know it. It's gonna be awesome. You had a had a mess ecosystem mass flagging backfire over at Megan's earlier. Yeah, yeah. I mean that does happen. That does happen. And you know, there's who knows, who knows, who knows. It's crazy stuff, man. It's crazy stuff. I've seen it happen before. Ah, hey Max, how you doing? Good to see you. Good to see you. Good to see you. Welcome, welcome, welcome to the shit show. And speaking of welcoming, Sherry Walker, oh my gosh, I can't forget about you. No, sure, Cal. Thank you very much, and most definitely.
Welcome to the shit show.
Yes, every single day, a new flavor of fuckery. Cause everybody sucks, you see, and they're dumber than a bag of rocks. Monday, Tuesday, Wednesday, and then 4 more days of increasingly stupid, ridiculous, ignorant, balderdash, pop, cock, bollocks, and buggery. Living all over again. Yeah, bankruptcy case is taking LLP's property and camper. Yeah, I mean, it looks like she's up shit creek without a paddle. I mean, we'll just have to see how all of that works out. You never know. I mean, that's a big possibility. And welcome, 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 welcome. Oh yeah, thank you, Star. I appreciate that. Kisses, kisses, kisses. I love it. Yes, it is going to be a very interesting night tonight. We got some really good stuff, and someone reached out. Yeah, let me think exactly who that was. That was someone from Sugar Lime Blue reached out to me and said, "Hey, why don't you check this part out?" And I was like, yes, and thank you very much. Thank you very much. And they're probably in chat also. And they said, well, thanks for shouting out the band. And I said, not a problem. And I'll do it again. And so if you look on one of those posts, it's like a little Easter egg. You find it, you can find Sugar Lime Blues reach there and go check them out. They're just a little band out of Tennessee, and they they're just out there grinding away, and they have beautiful vocals, really good, interesting music. They may be grifting for a tent soon. They might be, or they'll have to figure out a way to get that camper moved. One of the two. Jeremy get LP property, but he has to pay JC like $8K. I mean, what was it? Weren't they asking for even more? I mean, I don't know. We'll just have to see how all that works out. I mean, JC got his ass handed to him yesterday. Judge didn't even hesitate to just say, "Hey, no, you can't do that. You can't file crap in this courtroom." And pretty much slapped it down. Said, no, that's not how this works. But let's do this first. We're going to finish off where we left off last night. I rewound it a little bit so we could sort of get back in the groove of it. Man, this angered me so much last night. I finished it, but you know, going on 3 hours, my brain is shot, and I think I'm getting sick. Hopefully not, but we'll see. We'll see. We'll have to see how that goes. Oh my gosh. Hey, Wolfgang. Yes, humbled. You should be. I love it. I love Wolfgang Ricky. Yeah, that's good people, man. Good people. All right, here we go. Let's go ahead and bring this up right here. Take your BP, man. I don't have blood pressure medicine. I might need it after this. Good Lord. Oh,
I'm not, because it's not imaged yet.
And there will be an open letter tonight. not on this, but on the new filing. You'll see.
Filed that prior to the hearing today, and it is the final judgment of injunction, or what they call is a protection order in Ohio.
Yep.
And it's far more, quite a bit further reaching than Florida's.
Where do you think the line, okay, maybe,
It was easier to get.
I mean,
Actually, a little
pretty
harder.
broad under subsection 7, not initiate or have contact with protected persons named in the order where their business is.
And there will be a contempt motion, I think, forthcoming for your Honor's consideration.
I'm sorry?
I expect there will be a contempt motion forthcoming for your Honor's consideration in relation to the violation of this no contact pursuant to Florida statute 741.315.
Your Honor, we've made no contact with him. Any contact that's been made has
Well,
been
wait a
made by
second, why would
Mr.
it be
Hales.
coming to me?
Under Florida statute 741.1315, you would be the appropriate court to hear the violation under the recognition of foreign protection orders. The statute.
Oh, that right there is a slap. Oh, the judge did not want to hear that. The judge did not want to hear that. This right here, I think this might have been what set the judge off. This might have been what set the judge off, because she violated the protection order. And Mark Feather reminded him, this is the proper forum for us to be bringing this in front of you right now, right here, Judge. So, you can hear it or not, but yeah, he goes right into the judge, and the judge hates it. Oh no, you're about to see the judge get slammed right here. This is beautiful. Listen to what he says to the judge.
Any contact that's been made has
Well,
been
wait a
made by
second, why would
Mr.
it be
Hales.
coming to me?
Under Florida statute 741.1315, you would be the appropriate court to hear the violation under the recognition of foreign protection orders, the statute, and full faith and credit under the United States Constitution.
Oh. He just called the judge out. I missed that. Oh, we'll see, Valley. We'll see how they try to spin it. That's what they do. Yeah, that was a smack right there, saying this is the proper place to bring it. We can bring it right now. We can bring it later. Ooh.
Wait, but you're saying based on conduct that I'm not aware of just yet, other than me suggesting you can communicate with her?
Well, I think
No, that's not what he said at all. Said that she has violated the protection order by stalking him. Your Honor, that's not what he said at all. Oh, the judge does not like it. Oh.
there is other conduct, Judge. It hasn't been filed. We were hoping to put this baby to bed today and let these people go on about their lives. That was kind of our prayer, but it looks, I'm afraid we may not be headed that way.
They could go on with their lives with an injunction or without an injunction is the issue. If you wanted to adjudicate it on its merits,
Yeah,
I don't want to deny anyone a chance to be heard.
And I'm grateful for that, Your Honor. We arrived at 1. I think we started being heard about 3. We indicated very early on that we weren't interested in continuance of this case. It sounds
Okay.
like we're being forced into that. When I agreed to represent Mr. Hales.
Well, between 1 and 3, so we could have heard your case first, yes, and we still wouldn't be done with it. And we would have about, what were there,
I think we would be.
Oh, I don't think you like this,
25,
Judge.
30 other people that would have been waiting for their case? Sorry, that's the way I called the court docket.
Your Honor, suggesting the court should do anything other than it's done, except that we really wanted to have this case resolved today so that these people, she needs peace, Judge. Mr. Hales and his wife need peace.
All right, so what do you expect in terms of her playing those videos? Is it going to take us, what, 30 more minutes? Are you going to waive
I honestly thought if I
cross-examination?
got the opportunity to cross-examine her and we showed you the law, that we could have walked home 30 minutes ago.
But you've been yammering, Judge.
I don't know how that's going to happen.
They don't want me to have my right to.
Oh no, he wants to give you your moment, and he wants to have your moment. Yeah, Sherry Hawk has become a YouTube member. Welcome, Cheryl. we will hit the we will hit that music a little bit later on. I don't want to interrupt this part of it because this is really important, but I wanted to recognize you there, sweetheart. Thank you very much, Cheryl. Thank you there. Thank you. Oh my gosh. This right here. Look at this. We're at 1 hour, 37 minutes, and it goes for another oh shit, like even longer. Almost 10 minutes.
30 more minutes, we can resolve this.
My belief was if I had the opportunity to examine this
How much
crime
time do you need to
petitioner,
cross-examine?
I think about 15 minutes probably.
And how much time do you think she needs to play the videos that she showed to you? Or the other thing that the court could do, I mean, that's the court did in Strober versus Harris. The court received all the videos and said the court would review them later. The court did not rule at the hearing, instead promising in light of the initial evidentiary objections to review all of the video material before making.
Yeah, see this judge, he's delaying. This judge right here is delaying. Him yammering about what the law is wasting time and delaying. That's all he's doing. He's trying to delay this because he knows that this is going to end up poorly if he allows it to continue. Because you can see it in his face. He was not expecting this at all. He was thinking, oh, I'll be able to prolong this and delay it out for another time. In the meantime, things are going to get much worse. Thank you very much. I appreciate that. I'll do so. Thank you. Sorry about that, Fran. I got you. Oh,
A decision. We're talking, I don't remember in that case if it was dozens or hundreds of hours. We could
It
do that
doesn't
here.
matter.
This is a case that is not your run-of-the-mill. I think we resolved.
oh no, actually it is a run-of-the-mill stalking. Pretty damn run-of-the-mill, Judge.
5 cases in an hour and a half, maybe 6, I don't know. Sometimes I resolve 10 in less than an hour. This is not one of those kinds of cases.
Well, I think it could be. I think we have to give an opportunity to examine the witness, maybe or maybe not present the testimony of the other witnesses that are familiar with the situation, and then look at the law. The law is very clear. Your Honor asked the questions, they weren't answered. There's no substantial emotional distress, which is what's required. It has to be. There's no competent substantial evidence to support that. We can end that hearing now.
We have a prima facie case from her testimony, not yet subject to cross-examination, that she's basically paralyzed in her own home, does not feel safe, can't leave the property,
And we can handle that in like less than 15 minutes, Judge. Less than 15 minutes. See, right there, this is bullshit on this judge. Absolute bullshit.
needs to use whatever tools within her capacity to board it up and to blockade it from other people, hundreds of them at times, videotaping her on a.
Unless she's lying. Judge, unless she's lying. If she is lying about this, that changes everything. If she's out there stirring up shit, then she's creating this drama for herself. It's just
daily basis, that she's suffering from an exacerbation of a prior condition of anxiety, that she's currently now in therapeutic intervention and seeking assistance for.
And which she didn't provide any proof of. This is all the kind of shit that it's all hearsay. None of it's been substantiated by any sort of evidence. And Mark is probably just sitting there going, man, I just want to, yeah, she can't, well, held alone, paralyzed her home, but openly admitted to running for a town council seat. Exactly. And that's why this looks so damn, this is wrong. This is just so wrong.
For that, that it's persistent, that it's ongoing, and that it's perceived as being threatening to her safety and the safety of her family. So that's what she said. Now, one could argue,
No, one doesn't have to argue, because you're supposed to be the judge, and you're not supposed to be the freaking attorney here. Like, here's the thing, Judge. We've not been able to provide any evidence to the contrary. You're not allowing us to do that. You're not allowing us to question the veracity of her statements. Yet you're willing to go out on a limb and stir up shit. And basically, make the case for her, and then rule on your own case that you just made for her. What a piece of shit.
oh, some ordinary person would just blow this off and get on with their life.
Hang up the phone.
And I mean, we'll get to that, and I suspect I'll get an argument about that. And
Oh, well, yeah, in a few weeks after, she's caused more stress.
I've read the cases you sent me ahead of time, and one was domestic, one was stalking. The domestic has a footnote that the stalking is part of domestic, and so they analyzed it that way. I'm with you. I know.
No, you're not.
It doesn't deny and should not deprive her the ability to present it. And I'm just not going to have my clerks wait here till after 5 o'clock and my court security.
No, I'm going to sit here and fucking ramble for the next 20 minutes whenever we could have handled this in short order.
And
Your Honor, can I say something? How
No, you can shut the fuck up. Sorry, excuse the language, but you can just shut up. Shut up, sit down, be quiet, it's not your turn to speak, but she's going to let him do it anyway because he's an asshole.
and here's another thing. The court's concerned by doing so, there's not a temporary injunction in place. So there's no.
No, there's a permanent injunction on her in place that should be heard before you, Your Honor. Oh.
Intermediate.
There's a permanent injunction in place.
In another court, yeah.
Yes, she can't come near him. He'll be okay.
So there's
So
no
how
such
did-
thing.
Yeah. So she can't come near him. So if she can't come near him, then she should have no problem staying away from him.
In
How did the
Florida,
video happen the other day?
ma'am, there's no such thing as a mutual injunction, but there's
Right.
a such thing as people having independent injunctions considered on their own merits. The standard of law in Ohio is preponderance of evidence. The standard here is a little higher, competent substantial evidence.
And there's no substantial evidence. There's no evidence whatsoever at all. Toxic plaintiff means toxic judge. Perfect shitstorm. Yeah, that's right.
May I say something that's pertinent to what you're talking
No.
about? He was asked in Ohio, can we make this a mutual order between you two? Both. He said no.
No, she asked the judge, and the judge said that's not how it works. That is bullshit, and that's a bold-faced fucking lie. That is not how it works in Ohio. We watched the case. That's that's exactly what the judge said. Said you can get one in Florida, but there is no mutual one here in the state of Ohio. That's not how it works. She's going to blame Jeremy for it, and of course this judge is going to side with her.
He said no, because then he couldn't be able to do what he's doing.
Which is why Florida law has a statutory provision. There's no such thing as mutual injunctions. However, there is, rare as it may be.
No, there is not.
Injunctions one person has against one person.
There's
and another
not in
person
Ohio.
against the same person. But they have to independently be evaluated on the merits of whether there's competent substantial evidence to support.
So what exactly were the judge and her doing during ex parte meetings? She was putting on a case in front of the judge. He was giving her legal advice. He was telling her what she needed to do, how she needed to do things. Instead of saying, I'm sorry, you don't have anything here. Your person isn't here. I can't hear this case. Goodbye, Miss Treston. That's all that should have happened. Sorry, your guy isn't here. We can set it up for a hearing later. No, I'm not hearing any of this case. You need to leave. Bye, Felicia. He should not have entertained her whatsoever. He gave her advice, and this is what got him removed from being able to do it. They did not think that those tapes would be found. Those ex parte meetings came into all of this after. At the time that Jeremy is sitting here, at the time that Mark Feather is sitting here, they had no idea of this judge's behavior.
Of the final judgment. And I don't know how much more serious that could be. You want to cruise through this, you know, we're not going to do that to the.
I just really wanted to cross-examine the witness, the only one we've heard from, and I wanted to present.
And deny her the ability to present the evidence. Ma'am, how long are the videos?
They're like 30 minutes.
Okay, 30 minutes, 15 minutes, which is never going to be 15:30. We're going to be here till 6:30 at earliest. We're going to have to reconvene.
Oh, and she was praying for this. She was totally praying for this.
There's just no option around that. Mr. Hales, I think if you want quick justice, you're not going to get justice at all. And if you want to spend 6 or 8 months in an appellate court process, you could end up with that. Or we could hear the whole case and allow the court to make a determination on the merits of this case, and it could result in an injunction or not.
But you already
what
have
your
heard the
lawyer's saying
case.
is it's going to result in a quick and speedy resolution with a dismissal. I guess he's predicting what I'm going to do.
No, you're predicting what you're going to do. He hasn't even presented anything. He's telling you, Judge, we can prove her bullshit right now, right here, right now. We can get this taken care of. He doesn't want to hear it. Does not want to hear it. It's not because he wants to go. It's not because he's got anything to do. It's not because that those people don't want to go home. That's all just a bunch of garbage. All that it is he knows, he's been told by somebody that Jeremy Hales is bad and we're through this and we're not going after her. Or he took it upon himself to act that way. Because this is absolute bullshit.
That's a really hypothesis without basis.
Could we take the witnesses that are present in the courtroom so that they won't be inconvenienced again, Your Honor? We have the mayor of Otter Creek present. We have her husband. They both like to testify. Could we do that in light of the limited time that we have available so that they won't have to return and be inconvenient?
They're going to be 5-minute witnesses?
Very brief.
Probably not. You're going to have a pro se
Probably not. Probably not.
litigant try to engage in cross-examination, not even understanding what that is, to ask questions?
That is pled. She filed the fucking case. What this judge is doing is so wrong right here. Saying, oh, well, you're going to say that a pro se witness, you think that a pro se witness is going, not understanding that why did she file this without an attorney? See, this is ridiculous. And this is showing where he is so biased right here. This was her choice. You think that this is going to change her? It's going to change her questions if you give her, what, a week, 2 weeks, a month, 3 years? You think it's going to change her questions? Fuck.
I think that's how it works.
Since this
Mark Feather's pretty right. I think that's exactly how it works.
case is so
In
crazy,
time,
can I
it
get
will
a
work.
lawyer
Yes, in time.
Oh, see, here she goes. Oh, since this case is so crazy, can I get a lawyer appointed to me?
appointed?
It takes time.
To-
You're trying to railroad it through.
No, you're trying to railroad Jeremy. Oh.
Honor, I'm
understand
not
that.
trying to
I
railroad it in.
understand
I'm
that.
trying to
Well, the court
convenience these
the
witnesses
court
who've been waiting
disagrees.
4 hours to testify.
And I've been doing what in the past 4 hours?
Fucking off, rambling on. Piece of shit.
Adjudicating the merits of about 6 other litigants, times 2, because there's 2 in each case. Some were served, some were not served.
Understood,
With
Your Honor.
witnesses, some without witnesses, some with supporters, not with supporters. I don't know, when we started, how many people were here, 25 or 30? Am I insensitive to these folks having to come back? No, I'm not. I'm
Good, I think we
completely
can deal-
cognizant of it. You guys
Well, then you're sitting there acting like a dick about it now. I mean, I understand your frustration, Judge, but understand that, you know, there's other people that if you would just shut your cake hole and stop pondering on the merits of shit and just do your job as a judge. I mean, are you not quick enough to understand the things that are going on? Fuck me.
want to come back on a Saturday or Sunday, I'll be here on a Saturday or Sunday. You want to come back at midnight, we'll be back at midnight. But I'm not going to put my clerks through that or my court security through that.
I'm just
can
suggesting that
you
we
not
can
understand
convenience the
that?
witnesses by taking their testimony now, Your Honor, if the
Yeah, see, you're a bitch, Judge. Just a little bitch. How's that?
court would consider it.
You know, the request is denied. It's mind-boggling.
Am I allowed at all to get a court-appointed lawyer in something
No. Shut up, woman. Sit down, Felicia.
like this?
No, ma'am, it's not a criminal case. There's no constitutional, there's a right to counsel, there's not a right to court-appointed counsel.
And I'm sorry that I'm not an attorney.
Want to come back tomorrow? Let's come back at 9 o'clock. I'll cancel what I got.
I would note that the petition is not properly sworn. Does that matter to the court?
Everything matters in all good time, in all due time, at the appropriate time, if you're making motions.
I move to dismiss the petition because it's not properly sworn.
You can make that argument tomorrow morning at 9 o'clock.
And you could have heard it right now. It just shows the judge's bias right there.
And if it's granted, we'll all go home at 9:15.
Can I ask what that means?
That means you're a fucking idiot and you didn't do this properly and you have to start all over again was what it should mean. What it should mean is a judge should deny it. He should deny the petition. He should have made that motion, and Feather should have made that motion before he even got in there. He should have just made the motion right then and there.
Ma'am, I'm not considering adjudicating a legal matter
All right,
without
I just don't know.
proper argument presented in support.
I think I have a doctor tomorrow, but
Well, tough shit, lady. These people have been sitting there for 4 hours and they're going to have to come back the next day. Tough shit.
So, are we reconvening at 9 o'clock?
that's fine. I have a doctor's
Your Honor.
appointment, but I'll cancel it.
Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning.
And that's very important. Exactly what he says. Listen very closely what he says.
I just don't know.
Proper argument
Listen to what he says.
presented in support.
I think I have a doctor tomorrow, but
So, are we reconvening at 9 o'clock?
that's fine. I have a doctor's
Your Honor.
appointment, but I'll cancel it.
Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning.
He has to be in Ohio court in relation to this situation. He has to be there tomorrow morning.
He has a flight out.
Well, who's the judge in Ohio? Why don't we reach out and see what they can do to accommodate us?
Judge
So in
Ross.
effect, we're not going to have it tomorrow because of Mr. Hale's.
I have other commitments
Calendar.
as well, Your Honor.
It's Judge
Okay,
Ross.
so your calendar and his calendar take priority over the court calendar, which I'm willing to change to accommodate. I want the record to reflect, I'm here to accommodate these litigants and these witnesses to resolve this case.
Thank you, Your
And
Honor.
if it
Oh, well, that's really now you're getting all bent on his shit because, I'm here to resolve this, these witnesses in this case, these litigants in this case. Oh, well, we appreciate that, Anya, but where was your moral outrage like just 5 minutes ago, whenever you were chastising me for, trying to get some of this shit resolved today? Where was your outrage? Now you're outraged because, my client has to be in another state tomorrow to sign shit.
Can't be done tomorrow, and you're asking for a continuance beyond tomorrow. I'll grant that, but I don't want anyone to be misled into thinking I'm shirking my responsibility to
No, everyone believes you shirked your responsibility immediately.
adjudicate this case on its merits.
Your Honor, we would be grateful to stay as long as it takes.
You're missing the point.
Oh yeah. Now I'm missing the point. Yeah. What isn't convenient for you now? See? All of a sudden the story changed. Oh, you're missing the point. Yeah, you petulant little bitch.
It's not about you and me. We have other participants in this.
Yes.
Okay? Our court staff.
And all of us are right here, right now. We're all here right now. Jesus.
And our court security. And so I'm shutting it down in about 6 minutes. And if you want to come back at 9 o'clock, it's offered to you all. If you can't come back or you're not willing to come back, we're going to do it next Wednesday at 1 o'clock, the 6th.
So next Wednesday at 1 o'clock. He changes the day. There he goes. I hope they find this. No, I hope not.
If you have a calendar conflict, you've got a week's time to make a change in your calendar.
Fine with me, Your Honor.
Family
We'll be
me.
back here Wednesday, December 6th at 1 p.m. We stand adjourned.
This is my second hearing in Levy County Courts with Judge Craig DeThomasis against Lynette Preston, if that's even her legal name. And I've already been lied about, straight-faced, from the judge, declaring that I have to provide proof that I was standing in a hearing in court in Ohio. Nobody said I was going to a hearing. It was said I had to fly to Ohio to take care of things for a hearing. Now this judge is going to take away my First Amendment right of speech. And yours as well.
And this is coming from Jeremy here, and I want to hit the points. Let me make sure that I've got the right one, because I have the whole video, and I'd much rather play the whole video. So give me just a second. I'm going to pull that. I want to pull the whole video, and then we'll come back to this one, and we can fast forward through some of the things that are in this. And give me just a second. Here we go. So this is, I think that's right. This is the, well, let me make sure I have this right. I want to make sure that we have the right thing here. Yeah, so it is the same one. It is the same one. I just wanted to double check. All right, here we go. Add this thing in here. December 6, 2023. Correct.
Hi, good afternoon. I'm Judge DeThomasis. It is 1:15, December 6, 2023. We are here in the matter of Preston and Hales, 38, 2023, DR 416. If I can just have Ms. Preston as the petitioner, if you can just announce your presence for the record, state your full name.
I'm Lynette Preston.
Okay,
I'm
thank
here.
you. You may be seated. Counsel?
Good afternoon, Judge. Randy Shockett, Shockett Law Group, Trenton, Florida, on behalf of the respondent.
Sir, announce your presence.
Jeremy Hales.
Okay, ma'am.
Martha Risk.
And are you Mr. Shockett?
No.
Okay, and then what is your purpose in being here?
Your Honor, she's in addition to being a witness, she's also one of the persons protected by the order in Ohio that we asked you to take judicial
So
notice
what
of.
would be the relevance of her being protected? She can, if she feels like she's placing herself too close to the petitioner in this case and is at risk, she should sit in the back of the courtroom. If she's a witness, she should not be sitting at counsel table.
Okay, well then you can, that's fine. Just sit right back here, please.
So we're here on several matters. The first thing I want to confirm here, hang on a second, let me pull up the case.
Waffle House in Minecraft, of course. Yes. I got you. I just couldn't pull that up. That'd be bad.
All right, so we're here.
Yes, Randy is currently his lawyer because of the shenanigans that happened, and we'll go back to the other one, but you have to understand that Randy is currently his attorney after the shenanigans that Lynette played.
Here pursuant to several matters of process. On November 29, an evidentiary hearing, an adjudicatory hearing was scheduled on the petitioner's affidavit, supplemental affidavit in support of petition for injunction for protection against stalking filed October 30th, along with the initial petition for injunction for protection against stalking filed September 7th. The case proceeded to hearing on November 29, at which time it became apparent to this court at or about 4:45 p.m. that the petitioner was not yet concluded in her presentation of her case in chief. The case involved and included video footage, documentary evidence, and lengthy testimony of a pro se litigant that was not completed, and certainly in consideration of allowing the petitioner to conclude presentation of her case, and likewise providing the respondent and his counsel at that time opportunity to be heard in opposition, including but not limited to cross-examination of the petitioner and
Oh yeah, now this ought to be good. So we're already 3 minutes in. He's given lay down of the case, what's happening. But what happens, it gets even more ridiculous.
presentation of evidence, either in the form of testimony and or other physical evidence, which could include videos, photographs, and according to counsel for the respondent at the time, at least 2 witnesses that were identified as being present in the courtroom.
Correct?
Bottom line is it became apparent to this court that there was no way that
Bottom line is, Judge, you have no reason to be speaking. Blah, blah, blah. You biased ass, sorry, excuse for a judge. Yes. At this point, Judge, you don't need to speak anymore. Are you ready to present your case, Ms. Preston? Are you ready to continue on? Have you got the videos uploaded where we can show those as counsel? Have you been able to view them? Well, let's get this show on the road. No, that's not what this judge does. No, he decides to yammer on for the next half an hour.
the case was going to conclude by the close of business, and the court expressed, and that record will reflect concerns for court officials and not wanting to cut the matter short. As a result of that, the court made inquiry and announced that the court would in fact clear the court's calendar for the following morning, November 30 at 9 a.m. to conclude these proceedings, balancing the need to adjudicate the case on its merits, the concerns and issues of the petitioner, the fact that there was no temporary injunction in place at the time, the need for the respondent to get a resolution, which at times, which was inexplicable.
It was not inexplicable.
Characterized by his counsel at the time of, Judge, this will just take a few minutes, when at the
now we're at like the 5-minute mark and you still haven't shut your cake hole.
same time, talking out of the other side of his mouth, he had 2 witnesses at least. He had
What the fuck, Judge? Listen to his bullshit.
to get a resolution, which at times, which was inexplicable, characterized by his counsel at the time of, Judge, this will just take a few minutes, when at the same time, talking out of the other side of his mouth, he had two
Oh, that is bullshit right there, Judge. That's bullshit.
witnesses at least. He had a desire to cross-examine the petitioner. He raised issues of, Judge, does it matter to you? I think it was.
Oh, this judge is butthurt. Yeah, you're a little butthurt bitch right now, acting like a little whiny bitch. Oh, well, he made me look like an idiot.
Like a rhetorical question, or I don't know that he wanted it to be adjudicated, but nonetheless, the court did not. Judge, does it make
You're a piece of shit, Judge.
any difference that the petition was not even sworn to? Which I said, yeah, all legal issues, all factual matters are important to the court if they need to be adjudicated. So I don't know what that meant, but
It meant that you allowed things to come in to evidence that should have never been allowed in as evidence, is what he meant, Your Honor.
nonetheless, the petition from September 7, 2023, which is at issue, was sworn to before a deputy clerk of court. The supplemental petition filed October 30th, 2023, was sworn to before a deputy clerk of court. The petitioner herself on November 29 at 3:09:32 seconds was sworn by the court. And so, once again, inexplicably, I don't know what he was talking about, but.
Oh, he was talking about the law, the thing that you were supposed to be following, Judge. The things that you're supposed to be doing. This is why you got kicked off this case. The appeals court had a lot to say about you and your behavior.
It became moot. Doesn't mean that it's not relevant or remains moot, but it's in that context that.
Then I can basically do whatever the fuck I want to do. And if anybody goes against what I do, then, they're wrong.
And Mr. Shockett, you weren't here, but counsel for Mr. Hales at the time represented, we could resolve this in minutes.
Could have.
And
Yes.
in the history of jurisprudence, I don't know of anyone that's ever cross-examined a petitioner who presented 2 hours of testimony, confronted video evidence.
Well, that's the thing. She didn't present 2 hours of testimony. That's the thing. She didn't present 2 hours of testimony. You presented like an hour and a half of your own bullshit testimony.
It's documented area.
The appeals court said that he was absolutely wrong and removed him from ever handling another case with Jeremy or Lynette. He showed absolute bias in this. That's what the appeals court found.
Documentary evidence, possibly presenting his own client. The court expressed under 9615 an intent to possibly ask the respondent several questions and present 2 other witnesses, all of which would be subject to cross-examination in a matter of minutes.
Thousands of minutes, maybe.
And so, the relevance.
So it doesn't matter, Judge. That counsel isn't there anymore. So let's move on. Can we move on, Judge? Can we move on past your little butthurt state? Can you get can you pull that tennis racket out of your ass?
Of the court setting this record is what we now need to address here.
Quite a few.
This afternoon. On November 29 at the close of business, that Wednesday, the court offered that we will reconvene the following morning at 9 a.m. Give me just a second here. I've got so many documents, I don't know that I have.
Yeah, you got so many documents. I'm so flummoxed. Get your shit together, Judge. You got to read him the riot act now, because you've got things to do, but you don't have your shit together. You're trying to try the case, you're trying to hear the case, you're trying to resolve an issue, but you're acting as her attorney, you're acting as the judge, and you're acting as if Jeremy is absolutely in the wrong and he's your client, all in one motion.
I'll deal with this first. So at that time, the court mentioned we'll reconvene at 9 a.m. The petitioner mentioned to the court that despite having a medical appointment for the following morning, she would change that or reschedule that appointment for the purposes of proceeding with the matters to be adjudicated that following morning. And so,
Yes, and she also agreed that she would come back on the 6th.
not being insensitive to the fact that she would have to reschedule, the court accepted her representation. She could be here, was willing to be here, she would reschedule.
Jeremy could not because he had to be on a plane to get to Ohio to be there for signing of documents or something of that sort, and that's what they told the judge.
When turning to the respondent and his counsel, what was represented to the court was, one, that the respondent himself, and the language was to the effect
of bullshit that you wrote down that was not true.
He had
to be in Ohio to resolve the protective order. He had to be there. He had to do a notary, you have to be there in person. Some states will allow you to do online notaries. Some places will allow you to do that. Certain states will, certain counties, certain jurisdictions. Ohio is not one of those. He had to be there in person so they could see his signature to do any sort of notary.
He had to be present in Ohio the following morning.
Yes.
To address matters relevant to those being considered by this court.
No, they were part of the protective order that should have been considered by this court that this judge refused to look at.
That he had a flight out and needed to be in Ohio tomorrow morning, having to address matters in Ohio related to this situation.
Right there.
And
that's exactly what was said.
That representation was made and considered by the court. In addition, counsel at that time for the respondent stated, and another thing in effect, Judge, I've got a calendar conflict for tomorrow morning. Again.
Oh, well, that's on him, but he's not counsel for him.
And this court is obligated to consider the potential impact upon continuance to the petitioner without having a temporary injunction in place. Nonetheless, the court at that time stated we would reconvene today's date, December 6, 2023 at 1 p.m. Counsel for Mr. Hales was present, did not object to schedule.
Well, of course he didn't object because he wasn't even paying attention to you. You closed the hearing.
Scheduling it for today at 1 o'clock, agreed to schedule it for today at 1 o'clock. His assistant, who I'm familiar with, was present with him. And again, I didn't ask them this, but it would not be too presumptuous to think that the lawyer should know what his calendar is.
But it is presumptuous.
When I suggested the next day at 9 in the morning, he didn't tell me what his calendar conflict, nor did I inquire, but he said he had one. When I said, okay, next Wednesday, 1 o'clock, no objection, actual agreement to scheduling it. His assistant, again, I don't know that she would have done this, but it wouldn't be a far stretch to think two heads thinking better than one would say, hey, you got a calendar conflict, take a peek at your calendar, or hey, take a moment. Absolutely provided to him. Bottom line is, everyone was in agreement that today at 1 o'clock we
No,
hear
you were
this
in a
matter.
rush to get out of there, Judge. Lie.
Subsequent to that, at 5:56 p.m. on a Friday, Mr. Feather, then counsel for Mr. Hales, excuse me, files a motion to continue. The close of business on a Friday effectively becomes Monday as a practical matter, effectively becomes 48 hours or so before the start of this hearing, and the motion to continue, and at great length, this court entered an order denying the motion to continue on December 4. That motion to continue on its face was insufficient to grant the relief being requested. Number two, made no representation or no affirmance or no position
All right.
stated with
So here we are,
regards to
15 minutes
what
in,
the
Judge.
petitioner's
You got to a
position
point.
might be, or that contact was made to see if she objects or not.
It doesn't matter, Judge. Move on. Oh, that is awesome. Look at that. Megan ended at about 1,700 in super chats. Thanks, Ecosystem. And if you want to throw some breadsticks this way, they're always welcome. We don't object to that. He did yell, Mark Feather. Yeah. He's about to. Not yet. He hasn't. Rightly so, dumbass. The new attorney has to give time to get caught up on the case. Exactly. And Josh Silverman was a friend of the judge, and Randy was treated just as badly as he treated Mark. Mm-hmm.
Did not suggest when it might be continued to, if the court did continue it, and generally failed to establish any good cause for the requested continuance. Additionally, on the 29th, at the close of the proceedings, when the court directed and suggested and got agreement from counsel that we'd be here at 1 o'clock on 12/6 to hear this matter, the court also provided an admonition to everybody, to all parties. And the court said to respondent's
right,
counsel,
bingo.
in the presence of his assistant, to his client, to the petitioner, the hearing will take place on 12.
The judge is horrible, but the attorney has to object. It has to be on the record, but true, this judge treated everyone. Yes. But that's the thing. There was no, he couldn't object or anything. That's the problem. The certain things that the judge is stating, we just watched how that case ended. Just watched how that case ended. And this judge just moved on with his shit.
12/6 at 1 p.m. If any calendar conflict arises, you'll have a week to take care of it by rescheduling whatever matter comes up that would otherwise potentially be in conflict. I made it really clear, this takes priority. These types of cases take priority. This particular case takes priority. This is a case we already started. This is a case that could have been concluded the following morning. This is a case that the respondent and his counsel wanted the continuance. They were granted that continuance. They don't object to the continuance. They agree to the continuance, and then they're asking for another continuance. Inexplicable, without good cause, it was denied. In addition to that,
You're just trying to cover your ass, Judge. I understand.
the court and Mr. Hales, you might have said one or two things, I don't know. You weren't presented yet as a witness. Your lawyer represented to this court certain things on your behalf, and I have to accept those. I didn't question those, but you may be thinking, well, now he's questioning because
13 minutes and a half this judge has been talking. Going on 14 minutes, he hasn't shut up.
I directed the respondent to present proof of travel and his appearance in court in Ohio. Because quite frankly,
that's not what he said. He did not say that he had an appearance in court in Ohio. That's not what he said. See, now you're changing it, Judge.
that became the basis of the continuance. And in part, I get to in a moment, we're now dealing with a second successive motion to continue filed by present counsel, Mr. Shockett, who's here, on different grounds, but we'll get to that. We'll get to that in a minute.
Oh yeah.
But in part,
but right now we're going to ramble on just for a while longer because what else can we do?
because we now have that, it becomes even that much more important that the compliance issue is addressed. And the court asked for 3 things in that order. And the court has not yet received compliance. The court asked for 1, written documentary proof of the travel itinerary corroborating that he did travel by plane to Ohio, to be present in time for a hearing on the morning of 11/30/23.
But it wasn't a hearing, Judge. That's where you were sadly mistaken. It was in matters related to this case. It was in matters related to this case. Never said it was a hearing.
And if it wasn't for a hearing, whatever, to present written documentation confirming and corroborating that he did in fact have a required court appearance in Ohio, scheduled for the morning of.
That's not what he said either. See, now you're already making assumptions. Nobody ever said hearing except for this judge. So you're asking for things, Judge, that can't be given. They can't be provided because there was no hearing. He can provide his travel itinerary and say, well, I had to be here. This is whenever I traveled. This is whenever I had to be there. This is how I had to go. This is how I had to do this. You know, you're also talking about the middle of winter in Ohio. You don't know if planes are going to be late. You don't know anything about that. You want to get there as early as you can. There could be a storm rolling in. And this judge is being absolutely unrealistic on his expectations of what he's going to get.
11/30/23, and 3, that he attended such proceeding. What has now been provided to the court, styled as, quote, notice of compliance with court's order dated December 4, 2023, is inadequate, insufficient, and does not respond fully to the order directing proof of compliance. What has been.
Yes, he did. He provided evidence. He provided evidence in this, and the judge is full of shit. It was given. He gave him everything that he could give him. He can't provide things that are a lie.
Provided appears to be a copy of a boarding pass showing a November 30th, 10 a.m. flight from Tampa to Cleveland.
Okay. So there you go. Trader penalty. I was over on Megan's channel. Love you, Cynthia. Thank you very much for the $2 super chat. It's so kind. That's so kind of you. And it's all right to be hanging out with the Megan and the Tug because they good people. I am here.
And a return boarding pass from Cleveland to Tampa on December 3rd.
That's right, GCU.
And so the first issue that we need to resolve here is whether or not Mr. Hales has provided the court with the compliance pursuant to that order. And my intent is to ask several questions to get that resolved so we can proceed with the other matters scheduled for today. Mr. Hales, if you could raise your right hand.
Your Honor, real quick, may I be heard on that just to give you an introduction before we do this? Because I just got some information from his Ohio lawyer that I think is relevant. Okay, may I be heard?
Yeah. That right there would be, you know, if it's going to be something that's relevant and the judge would shut his cake hole, 15 and a half minutes this judge rambled on.
Sure.
Okay, so thank you, and I appreciate your getting me up to speed about what happened. I haven't talked to Mr. Feather, but what I understand from him, it was a misunderstanding about a hearing in court that morning. He went to his lawyer, and this is what I want to, which I just got by email from his lawyer. Him had us draft and sign affidavits which had to be notarized in Ohio, and I've got them here, which were signed in Ohio related to the injunction hearing in Ohio. They were signed on December 1st, 2023. May I?
Sure.
Okay, so there's one for John Cook. And there's one for Lynette Cook. And I just got these by email this morning from this lawyer, asking the same thing.
Steve Wells, Starzy.
Can I object to this since it's not truthful?
In a second, I'll get to you in just a second. Let me see what it is.
Can I object to this? Because it's not truthful. Hey, Feather Catcher.
Mr. Hales, if you can raise your right hand. Solemnly swear or affirm the testimony about to give in this cause will be the truth, whole truth, and nothing but the truth.
Judge is such an asshole. Yep.
You are Jeremy Hales, the respondent in this action.
Yes.
You were present in court on November 29 when your counsel represented that you had to be in court the following morning in Ohio.
I was in court. I apologize. I was in court. My lawyer did not say verbatim I had to be in a trial in Ohio. He said that I had.
I didn't say the word trial either. If that's
Or
what you're,
You just did. You just said that. You just said it. We'll rewind it. You just said that. This guy related to Deuce or something?
Mr. Hales, if you can raise your right hand. Solemnly swear or affirm the testimony about to give in this cause will be the truth, whole truth, and nothing but the truth.
I do.
You are Jeremy Hales, the respondent in this action.
Yes.
You were present in court on November 29 when your counsel represented that you had to be in court the following morning in Ohio.
Right there. That's what he said. In court.
I was in court. I apologize. I was in court. My lawyer did not say verbatim I had to be in a trial in Ohio. He said that I had.
I didn't say the word trial either.
No, you
If
did.
that's what
Or
you
in
said,
court,
if I
my-
misspoke, it's not, I didn't say trial.
In court.
My legal counsel did not state I needed to be in court. He stated that I needed to be in Ohio to take care of things with the court.
Having to address matters in Ohio related to this situation, correct?
Correct.
Correct.
So did you or did you not have a court appearance?
I did not have a court appearance, nor was it stated that I had a court appearance.
Okay. And so what was it, you had to go there to sign some documents? That's what's been presented to the court?
Yes, sir.
Okay, so the court is familiar with, because the court does this on a daily basis, sometimes dozens of times, sometimes hundreds of times a day, which is signing documents from anywhere on the planet.
Oh, yeah. But smart ass, notaries, you have to be there in person. Smart ass. Yeah, you can sign documents anywhere on the planet. You can do DocuSign. You can do all that kind of stuff. But for a notary, you have to do those in person. Been watching for ages. Just found out I was gifted a membership. Thanks, my fairy membership giftee. Thank you, Lynette. Lynette, maybe I'm not sure the name, but I'll just say Johnston. Welcome, welcome, welcome. Thank you for being here. Now he's going to nitpick. Yep. Now he's going to be an ass about it.
Why did you have to go to Ohio to sign your name to a document?
Filing for contempt of court on the civil protection orders in Ohio, my legal counsel asked if I would fly and come and notarize and file in the court system.
That's not responsive to my question.
That's very responsive to your question, because you have to be there to have it notarized to show that you're signing those papers.
Question is, why would you have to physically be there in Ohio?
For a notary, you have to physically be there. They have to physically see you sign it. And depending on the paperwork, sometimes you have to sign it. Sometimes you have to sign it in front of a...
Ohio to sign a document that could be signed in many, many other ways.
But it had to be notarized there.
Without you physically being present in Ohio to sign it.
My legal counsel in Ohio said I needed to be in person to sign the documents.
Who's your legal counsel?
Eli Heller.
Eli, last name?
Heller.
Heller?
Yes.
Where is the office?
In Cuyahoga Falls, Ohio.
So you're saying your lawyer gave you advice, by the way, anything you're talking about in terms of advice of your counsel, if you're choosing to talk about, because I'm not asking you to waive any attorney-client privilege.
He's not waiving any attorney-client privilege. He's telling you I had to be in court for a document Whenever it gets signed, the notary has to be there. He doesn't know the legal terminology for this, dipweed, but you should know this.
But you're raising as a defense to your non-compliance with this court's order that your lawyer told you you had to be there to sign documents.
Yes.
Could you tell me, if you have a basis, why, from your perspective or from what you know about your need to be there, what was your need to be there as opposed?
It's my attorney told me I needed to be there. Your Honor, if you got a question about that, you're welcome to take that up with my attorney. Hey, thank you. Thank you very much, Valor. Appreciate you, brother. And I'll hit all the super chats at the end tonight.
To all other forms of the ability to sign a document from literally anywhere on the planet these days?
From my understanding, notarization in person with my lawyer and then filing in the Ohio courts.
Why couldn't you use a notary here in Florida with your lawyer here in Florida?
I did not.
He did not ask. He just did what his attorney told him to. That's not how it works, Judge. He already had his tickets, everything's already set up. He did not expect that Your Honor was going to take an extra, 4 hours in the morning to have the initial hearing. They could have finished this up, and you're nitpicking like a little bitch because you got your ass handed to you.
Ask that question, Your Honor.
So you're unaware whether you could have done it that way?
I am unaware.
All right. Why is it not signed until December 1st?
My flight was booked prearranged for the date that you've been provided, and then the meetings were already set per date as well.
The meetings for December 1st?
Yes, sir.
So you did not have to be in Ohio on November 30th at 9 a.m.
Well, if you want to put it that way, you could probably say that, but are you the judge here, or you just acting like a complete prick? Because, we don't know what the weather is going to do, Your Honor. We could have had a storm. This was an important meeting for me to be there for. I could have booked another flight to come back, but nobody was available at that point in time. Nobody said he had to be in Ohio. Well, he did have to be in Ohio. He had to be in Ohio to sign those documents. He already had the flight. The flight flies in, and it's already pre-booked because he was not expecting their bullshit to run all skewered. So you want it to cost him thousands of dollars to fly from one state to the other over this bullshit is what you're saying, Judge. You're wanting it to cost him thousands of dollars and time out of his schedule over bullshit. Nitpicky little whore.
Sir, I had to be at the Tampa airport for my flight at 9 a.m. So no, I did not need to be in Ohio at 9 a.m. I needed to be at the Tampa airport at 9 a.m.
So your lawyer's representation that you need to be in Ohio tomorrow morning, that was stated to this court at or about 4:45 to 5 p.m. on 11/29. So tomorrow morning would be the a.m. of 11:30. You're stating under oath to this court you did not physically have to be there in Ohio on the morning of November 30th.
Your Honor, I had tickets pre-purchased, so to make my flight for my appearances in Ohio, there would not have, I don't believe there would have been another opportunity to actually fly into Ohio to be able to make my appearances on
Your lawyer
time.
never used those words and said, well, Judge, just to be accurate.
Well, no, the judge didn't call you a complete fucking prick, but that doesn't change the fact that that's what you are. I mean, if you want to nitpick about this, you fucking asshole.
And just to be truthful and just to articulate our basis for asking for a continuance of a case that involves a
I would venture to guess, and in my opinion, that he's having conversations with him. It just he gives off that impression of oh, so I nitpick your bullshit, but you're going to nitpick mine. You know, you get pissed off whenever I nitpick your shenanigans, but you're going to get all pissy with me and try to nitpick every little thing. Yeah, this is still advocating for LP. Yes, it is.
Petition for protection against stalking, for which there's no temporary injunction, so that you have all the facts and circumstances. Let me tell you, my client doesn't have to be there tomorrow morning, but for the fact that he's already paid for a ticket that will allow him to get there the day before he has to be there to sign a document, and maybe the court at that time could have inquired of counsel. Counsel, could you tell me, just hypothetically, why would somebody have to physically be in Ohio to sign a document?
Fuck you, Judge. Fuck you. Simple as that. Fuck you.
Right? That never took place. And I know that because I've reviewed the hearing half a dozen times, and I was the one who was presiding over the hearing.
Oh, so you reviewed the entire hearing. You spent 6 hours reviewing this hearing. Oh. Doreen, she did an amazing job. Oh, awesome. Megan and Larry did a breakdown of the complaint written by Doreen. She did an amazing job. Yes, she did. Yeah, Doreen's pretty damn awesome. Yeah, what a sarcastic bastard. Yeah, the judge is absurd.
What was represented to this court by your lawyer.
No, what you assumed, Judge, what you assumed, and you made an ass of yourself,
is that you had to be in Ohio tomorrow morning, which would have been November 30th, a.m. Having to address, when lawyers use that word, has to, must, shall, requirement, be in Ohio related to this situation. And what I'm now hearing is you really didn't have to be there till the next day. It may be that you really didn't have to be there at all, because all what you did was sign a document, not see a judge who required you to make a court appearance.
Judge, may I ask some questions?
In a moment, you can. Is that accurate, Mr. Hales?
No.
Is that the more accurate representation?
I think the accurate representation is there is a scheduling conflict. And on my part, a very important scheduling conflict, to be able to catch my flight, to be able to go to the sheriff's station to pick up my certified civil protection orders against Lynette Preston and John Cook, because they cannot be served to anybody else. I had to be in Ohio in person at Summit County Sheriff to receive those, then to go to see my lawyer.
Why did you have to get served with something?
Because that's the way the system works. I'm served as well. She's served, he's served, I'm served.
The issue is of November 30th in the morning, you did not.
He had to be on a flight, Your Honor. So you've already wasted almost a half an hour of the court's time with your bullshit, Judge.
Not need to be there to be served. You did not, now we know, need to be there to sign any documents.
No, no, Your Honor, I could just fucking magically appear. How's that? I just click my heels 3 times and I'm in Ohio. Is that how travel works now, Judge?
Because it doesn't even take place till the December 1st date.
No, sir. The issue is I had a scheduled flight to be there and do not believe I could have gotten another flight to be there on time.
Did you ever set your lawyer straight when he was standing in front of this court saying that you had to?
No, and he doesn't need to. Because your nitpicky shit does not fucking matter.
Address matters in Ohio tomorrow morning related to this situation?
I have this.
Are you representing Lynette as your client now, Your Honor? I mean, that would be my question.
Discuss this with my representation, yes.
He stood in court. You were standing right next to him. We're sitting right next to him.
No, I was sitting down. His back was turned to you, and he was asking me questions whenever you were on rambling and listening to your client over there, Lynette.
To him, where he said nothing about it's because flight's tomorrow and it might cost him an inconvenience. And I would have considered that. There's no doubt that I would have.
So then why is this
a problem?
So why is this even a fucking point? Why is this even a point, Judge? Move on.
Would have also inquired, like I am now. Tell me how, because I don't know of any law that requires you to physically be present in another state when you can.
Hey, I don't give 2 shits. That's not my job. That's not my job. How about this? You reach out to my attorney and speak with them there, fuckwad.
Sign it here. We have plenty of notaries. You could swear before me. You could have sworn a document.
Sure. But with your behavior, I don't think I would have wanted sworn shit in front of you.
In court the following morning and then sent it to your lawyer up there. And I could check with your lawyer in Ohio. We'll find out whether that process could have been available to you to accommodate you and save you from going to Ohio and back to Florida. My concern is your lawyer was misrepresenting something to the court and got away with it with a continuance to today. And what's relevant about that, aside from the issues with the lawyer, is that we're now here today with another lawyer asking for another continuance, which is putting you in a jam. I've got to be concerned about your ability to present your case, because I've got to decide this case for the interests of both of you. And
and you're going to ramble on. Let's see, we're at 26 minutes already, and you still haven't made a fucking point, except for go after my client, Your Honor. Hi, from New Zealand, loving your channel. Well, thank you, Phil Anderson. I appreciate it. That's wonderful. Welcome from New Zealand. And what I'm going to do is I want to hit a few of these wonderful people that have come in here and been so kind to throw that breadstick money. And if you feel like throwing more, it is always welcome. Phil Henderson with the $10. Valor News Parody with the 5 says, thank you, Shizzy. And Valor has been here for 12 months. Grudge is the anti-Mark Feather ecosystem. Yes, indeed. And been watching for ages. Just found out his gifted membership. Thanks, my fairy membership giftee. And this is for the rest of you here.
Welcome to the shit show.
Oh, yes. Every single day. A new flavor of buggery, 'cause everybody sucks, you see, and they're dumber than the banks. Monday, Tuesday, Wednesday, and then 4 more days of increasingly stupid, ridiculous, ignorant, balderdash, poppycock, bollocks, and buggery. Living all over again. Ooh. Love it. And Cynthia Firefairy with a $2 trader penalty. I was over on Megan's channel. Nah, she's absolutely awesome. I've never object to having people come over from Tug and Megan. This is why Randy said to Jeremy, just accept TPO. We will live to fight another day. Yeah. Hopefully next year, Judge won't be voted back in. He'll be admitted to a retirement home, sitting in a chair dribbling out of the corner of his mouth or other orifices. Chat, hit that thumbs up while you're here. Most definitely. Make it feel good. Make it feel good.
the lawyering is standing in the way, to some extent, of that.
So,
Now, I
so
haven't
you're
gotten to
still
the next
rambling,
motion
Judge.
continue. We're going to get to it in a second. The court makes a finding that there is non-compliance with this court's order dated December 4, 2023, which included the language that there were requirements to establish proof of the travel
right.
itinerary, that he did travel by plane to Ohio in time for a hearing on the morning of 12/1,
It wasn't a hearing.
to corroborate that he did appear and that he was required to be there, when we now know that's not exactly what it was, nor would it have been if properly, truthfully represented to the court. And I'm not saying, Mr. Hales, it's all on you, but you're sitting there while your lawyer is representing to this court and misleading the court, and nothing was done to prevent it. And nonetheless, what's relevant for today is that bought you a continuance, and now you're asking for another one. And I'm going to hear from Mr. Shockett in a moment about this next continuance. So as of now, there's non-compliance with the court's prior order, based largely in part on the misrepresentations and the less than candid representations made to this tribunal on November 29 by counsel at the time, Mr. Feather. With respect to that is before this court today,
Today.
the context, again, is significant because
Oh,
the
yeah.
nature of this case, the nature of the pleadings, the nature of the issues that arise, the fact that it involves allegations and averments of long-term behavior, that it included the presentation of multiple videotape items of evidentiary value, document.
Oh, but it wasn't of evidentiary value. See, this is bullshit. This is bullshit.
Evidence, that there were additional witnesses, that we had
Damn.
a pro se petitioner who had to go first with her case in chief, that we had a petition, a supplemental petition, which were separate pleadings. Each of them were fairly lengthy. The court at the time of the hearing on November 29th also made comment to counsel, and I don't have any indication that counsel was actually aware of what the court was even talking about. Maybe he was, but that there was a statutory change in October of 2021, that since the statutory change, there's really has been no appellate court decision addressing these facts in light of the statutory change, that the case precedent prior to the statutory change that addressed a very similar fact pattern, which I mentioned to counsel.
What's the time,
Strober
Shizzy?
versus Harris.
29
decided January
minutes.
5, 2022 by the 2nd DCA, 332 Southern 3rd,
Oh,
1079.
it gets worse.
Said in part, relevant part, that it reversed that court's determination that there was not a basis for a stalking injunction, and said that a crucial part of the statutory definition that the court conspicuously failed to address was the issue of posting, that's what that case was all about, publicly posted videos.
So you're just taking it at face value that somebody's posting things, not Jeremy. It could have been anybody posting anything, anywhere, at any point in time about anything, but yet you're going to blame Jeremy for it, is what you're saying, Judge. It's just the same stuff over and over again. It's Groundhog Day. Yeah. Well, let's and then he goes off about the communications and Mr. Shockett, you're now advancing argument. Yeah, 33 minutes in.
Court already covered the fact that I granted the continuance. It's clear to this court,
Yeah.
receipt of the after hours motion,
Don't care.
where I must have said on multiple occasions at the close of the case to Mr. Feather, I've only heard one side of the case and not
But this is Mr. Feather.
even the entire side of that case. I don't want to deny, I have no intention of denying the respondent ability
But you're doing it right now.
to present contrary evidence or contradict or confront the evidence
Bingo.
presented against him. And so one issue, and Mr. Shockett, I just got to ask, because there's a notice of appearance that's styled as notice of appearance as co-counsel. Then there's your motion filed 12/5/23 at 12:53 p.m., styled as an urgent motion for continuance that states under subsection 2, co-counsel Mr. Feather, so that's consistent with your notice of co-counsel, is not available on 12/6. But then it adds this phrase, more importantly, respondent wishes to have undersigned counsel represent him at the continued hearing. There's a couple ways to read that. One is,
No, there's only one way to read that, Judge. There's only one way to read that. His decision was to take civil rights was the start of my parody. Come at me, Grudge. That's right, Valor. That's right. If you haven't checked out Valor News parody, he's got some good stuff. Yes. Wolfgang remembers.
he wants you and not Mr. Feather at the continued hearing, meaning today is the continued hearing, and you're here. So one way to read this is the respondent gets that which he wants, and which, quite frankly, from the court's perspective, he deserves, his choice of counsel here at this continued hearing. But then it's a motion to continue, so I presume that when you say continued hearing, you're saying, if I continue it to the next hearing. And so that's one issue, because it would be presumptuous without any basis to be presumptuous, that I.
Except that you're being presumptuous and acting presumptuous and pretentious and a dick.
Charles, I don't know. He is,
I don't know where there's any precedent for such.
No, there's plenty.
process. And I don't know that necessarily that's intended, but I don't know what's intended, nor am I questioning your involvement in the case, but I gotta know what your status is.
okay, thanks, Judge. Thank you. May it please the court. My status is to continue to represent him as lead counsel in this case. That clarifies it. Here, today, if we don't finish it, whatever happens going forward, and maybe Mr. Feather with Charles, I don't know. He is at a doctor's appointment, as I understand it, in Gainesville.
Well, here's another thing, and I don't want to be
Here's another
insensitive
thing.
about this.
Sure you
okay,
do.
but under the circumstances of this case, Mr. Feather didn't plead on November 29th at or about 5 p.m. He said, I can be there on December 6th at 1 o'clock.
Right.
So if it was an emergency that came up from November 29 to today's date, medical intervention of necessity, et cetera, clearly the court would have waited a lot different than, oh, Judge, I've got an appointment on December 6th at 1:45 that I didn't tell you about, and it doesn't say when it was scheduled, maybe after.
It doesn't matter. Bitch, 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 bitch.
So you're saying that if the relief is granted and it's continued, you're going to present as lead counsel.
That's right, Judge.
Have you considered what you would do if the continuance is denied? Are you prepared to proceed today?
As best I can, given the limits, Judge. I just got hired yesterday. I had 2 hearings this morning, working within reasonable human hours. I looked at stuff last night, but woefully unprepared because in that short a time. And also, now we do have the temporary injunction in place, so there's no prejudice.
Which I said,
Yeah.
it changes things a little bit.
Yeah,
So have you reviewed the proceedings from November 29?
not all of them, Judge. I don't have all the materials. I've asked for a transcript. I've ordered it, rush basis, so I can see the, I do have one of those AI transcripts,
Right?
but I don't trust it because I can already see some misspellings. And as you know, the devil's always in the details, so I'm waiting for the official transcript to be
So-
prepared. And also the witnesses.
So here's the thing, I'm not asking you to disclose attorney-client communication. In fact, I'm specifically stating I don't intend to do that. That being said, so I can work on a presumption here, which is when Mr. Hales contacts you, or you contact him, whatever, when you guys come into contact with each other about this pending matter, 12/6 at 1 p.m., you either had to tell him, I can be prepared despite the fact I only have 25 hours notice, or
No, I mean, you, and that's the thing. You'd like to think that you would, but in the situation, you're there. You're there at the will of an asshole, and you know that you're there at the will of an asshole, and there's nothing that you can do about it. You want to tell him it's going in contempt wouldn't get anything done, and he knows this. You're late again. That's all right. That's all right. We'll make you pay for it later. How's that?
you had to tell him, I could kind of try to be prepared, but I won't anyway near be as prepared as I could be or that I should be on your behalf. If I took I presume you had a conversation. I was in practice for 36 years representing people. You probably should have had a conversation.
You're in practice for 36 years representing people. And you're still in practice representing Lynette in this matter too, asshole.
I don't want to be too presumptuous. If I get a continuance, I'll be much more prepared than I am able to do in 25 hours. And so the relevance of the question, depending on how that conversation, either Mr. Hales willfully, intentionally, purposefully hired a lawyer who he knew absolutely could not be prepared to resolve this issue today.
Not true. You see, now you've got assumptions, Judge. You got unfounded assumptions on shit that you have no idea what you're talking. You're talking out your ass.
Or he hired a lawyer that he would know would not be prepared.
Or, you're just making wild assumptions and guesses and you're wrong on all of them. How's that? I like that one the best.
Hoping that that would be grounds to continue this, rather than go and find a lawyer who says, man, it's a short period of time, but man, I can do what I'll do, and I'll be prepared. I'll take your case. So I'm not questioning you and saying I'm not even getting into this, but I got to question the motives of Mr. Hale in gaining a continuance, because a continuance is a victory for someone who doesn't have a temporary injunction.
But he has a temporary injunction, you fuckwad.
Precluding entry of an injunction.
Correct.
Is in their favor, clearly.
Right.
And to the detriment of the petitioner.
But I think at some time, well, first of all, there's more that happened in the meeting that I'm not allowed to.
Well,
reveal.
I don't want you to, unless you guys are willing to waive. I'm not saying that. So that's what I'm saying. You either.
No, but that's what you're saying. You're saying you want to know what their plan is because you're trying to represent Lynette in this shit, asshole.
And I'm not saying that you were completely negligent in not telling your client, dude, you're hiring me and the hearing's 25 hours.
Fuck you. Nobody else would have been able to do it. Nobody else would have been able to do it. So what the fuck? Hey, Megan. Hello, Mr. Coop. How you doing, East Texas Cowboy? So he's saying Jeremy Hale should have hired a crappy lawyer that had plenty of time on his hands. Well, Deuce was available. Can't in court. You can't in court. You must keep decorum or be in contempt. And what they were saying is, I would have been held in contempt just to give them a piece of my mind. That's what they were saying. I wouldn't, but that's what they were saying.
Hours from now, how can I possibly be prepared? Or you said, I'm on the spot. I got it. I do this all.
Epic stream at Megan's. I bet it was, especially whenever I heard what happened to Megan. Oh yeah. Megan Red incoming. Yeah, she was laying down the law on him
all the time. Whatever, it only implicates Mr. Hale's decision to retain a lawyer who now is in front of a court saying, I cannot effectively, as competent as I want to be, represent.
Nobody could have been. So what are you rambling on about, Judge? Move on from this. You are so butthurt.
His interests. You're saying I'll do the best I can, and I know you will, but you're not saying I'm going to provide him effective representation. Now, there's no constitutional requirement of effective representation when it's counsel of your choice, and you knowingly hire somebody who tells you they can't be fully prepared. Or it might be that you hire somebody who can't be so that.
Or it might be that he hired an attorney because, the Lynette was pulling some shenanigans. And it might be that, that attorney that he hired said, yeah, I can take the case. We'll file a motion to basically get a continuance. And then we can move on from there. God, jeez Louise.
You shore up.
No, 43 minutes, 53 seconds. He has still been rambling on this same bullshit and hasn't stopped. Except for asking a couple of questions. What a garbage person.
To continue it.
Okay. So, first of all, we have the protection in place here of the TO. We have that. And that did come to my attention yesterday. I think it posted online like within an hour after I filed the motion. I knew that this was relevant in weighing the prejudice to both sides. And I can tell you as an officer of the court that this is not a case of just continuing counsels, and I'll be the lead counsel in this case. And so I think there's very legitimate grounds, given what we have here with this helps tip the scales, given this lack of.
Let me ask you another question. How do you plead under subsection 4 that the petitioner will not suffer any prejudice or inconvenience as a result of a continuance? How do you?
Well, it's a brief continuance, Judge. I don't think it's going to be any prejudice. And now
Well, what's brief? Because that's
Well,
another
that's
thing. The
when's
motion
our court.
doesn't
I'll do
ask-
this.
The motion doesn't ask for a particular period of time.
I don't have your, well, I would say as soon as you want. I mean, within reason, give me 10 days to get prepared and we'll be here in 10
Well,
days.
you know, I've been tempted to do this in the past, not with you, but with counsel that moves for continuance, but doesn't say how long. And I could have continued it from 1 o'clock to 1:30.
Oh, right, yeah.
I mean, I don't know how
Yeah.
long you need.
Yeah, right.
Right?
You want 20 days, I'll give you 20 minutes, right, yeah.
So, to say that there would be no prejudice or inconvenience, I mean, we know at a minimum the inconvenience is the petition was here on the 29th, agreed to be here on the 30th despite the fact that she would reschedule her doctor's appointment, then agreed if it accommodates them, and Judge, you're saying we can do it on the 6th, I'll be here on the 6th, she's here on the 6th, so there's some inconvenience.
Oh, and what about the inconvenience everybody had to suffer because you decided you wanted to go home the fuck early? Seems like people are in court at your whim. That's not how it's supposed to work, Judge. You know, it's not supposed to be at the whim of whatever you feel like that day, asshole.
And she'll have to come back again. I don't think that you filed this pleading when there was a temporary injunction in place.
Doesn't
I
matter.
don't know, what time was it?
Your filing is at 12:53 p.m.
On the 5th or the 4th?
On the 5th.
Well, this was filed on the 4th, Judge. Wasn't this order entered on the 4th? Or the 5th? I don't even know now. Entered on the 4th. This TRO.
And
Yeah.
so your position is that
My position is I'm sitting. That's my position, Judge. I'm sitting. I'm having to listen to your bullshit.
if the court has the temporary in place, there's no prejudice because she's got the protection that she's seeking.
Oh no, that's there's still one more hearing. This gets worse and worse. Welcome,
Temporary.
Raiders. Welcome.
Yeah, and you can continue there's a day, 15 days, I think, you can continue that if it gets continued. But yeah, the protections are in place.
With regards to inconvenience, why is
No, you're saying that you're asking whether these protections are in place. Protections are in place. The TRO is right there. The temporary restraining order is already in place. So what's the big deal? Give me a continuance so we can move on.
it not inconvenient for her to have to come back?
She's won, Judge. She's won. She has her injunction.
Well, no, she's asking for
She has her injunction. She's won. What are you talking about?
a final, at the start of the
understand.
proceedings, I ask all petitioners, are you here asking for a final judgment?
Right. Which would adopt the same standards, the same restrictions against him. Just a question of how long it's for.
Well, it's not, and I guess that's going to get us to another issue, which we'll get to in a minute, which is if there's
So there is a temporary restraining order. I'm holding it right here in my hand, Judge. Temporary restraining order. So she's basically already won her case. So what are you rambling on about?
temporary injunctive relief in place, it's going to have to include additional language than the general buffer zone language.
Okay.
And we can address that here in a second, but I guess you're not able.
So basically, I'm going to modify the TRO. And okay, can we just get the damn continuance? Fucking
To
moron.
disclose to this court
Oh.
whether Mr. Hales intentionally, willfully retained counsel that could not be prepared.
There were other issues we discussed. I really don't feel, I'd like to say it, but I can't.
Okay, if you can't, that's fine.
It's more than just that.
There's at least the appearance of manipulation of the court to continue it, to either allow continued behaviors that are intended, to allow what came out in evidence was a financial incentive to continue certain behaviors, because it came out in evidence on November 29 that.
No, there was no evidence presented. That's what I'm saying. See, this judge said, well, there was evidence presented, but it was not verified. It was not sussed out. It was random bullshit that she pulled up and issued to the court, and the court accepted it as true. So he's changed already right there. He's already changed his ruling on that. And Mark Feather, if Mark Feather would have known that this is how the judge was going to act, I mean, he had a suspicion that this was going to happen. That's why he was objecting to it. The judge says, well, you have no standing to object to it because she verified it. She verified her own shit.
Mr. Hales makes a financial profit from the actions that Ms. Preston is claiming.
That's that's an assumption. That is an assumption that he makes profit off of these actions. None of this has been proven whatsoever. You are making assumptions about something that he's never even had a chance to present his side of the case. Fuck me.
Are causing her substantial emotional distress.
And she's met that burden, which is a higher burden without evidence here.
Yes.
And, you know, she's basically.
Right, but what I'm saying is, on this point, is that the continuance could be to the benefit of Mr. Hales.
Well, it wasn't. And that's an assumption that you're making, Judge, based on what? Based on what? Your own assumptions on this? Oh, yeah, it ended up being 11 months though. Yeah. Well,
While it's to the detriment of Ms. Preston.
I just.
Because he's earning a living.
But he's prohibited from.
she's earning a living too, or she's supposed to. She's got her TRO. What the fuck?
Doing the acts that cause harm.
Well, that's the part we need to be clear about.
Okay, let's
in
be
the
clear about
temporary
it.
injunction.
Yeah, sure.
Because I don't think the temporary standard injunction that was previously ordered.
No, because I'm going to hit him with everything that I possibly fucking can. Oh, you piece of shit. Hold on just a second. I'm going to do something here real quick. Give me just a second. I'm going to pull up. We'll pull this one up here. So this is a good time to do this. This is a good time to do this one here. Now, this is Jeremy talking about this right here. And it's going to cut out a lot of the bullshit in between.
In Levy County courts with Judge Craig DeThomasis against Lynette Preston, if that's even her legal name. And I've already been lied about, straight-faced, from the judge, declaring that I have to provide proof that I was standing in a hearing in court in Ohio. Nobody said I was going to a hearing. It was said I had to fly to Ohio to take care of things for a hearing. Now this judge is going to take away my First Amendment right of speech.
Yep.
And yours as well.
The definition of cyberstalk, they included language. It states to engage in a course of conduct to communicate or cause to be communicated. And they added these words, directly or indirectly. Then it went back to the previous words, which reads as follows: words, images, or language by or through the use of electronic mail or electronic communication directed at, and then the legislature added these words, or pertaining to a specific person. And so the addition of the 6 words, directly or indirectly, and or pertaining to, clearly.
Oh, this judge doesn't wonder why he's recused. He absolutely knows now why he was recused from ever handling any more of Jeremy's cases, because of his actions in all of this shit.
Redefine the analysis the court must employ to evaluate these facts in light of that statutory change.
Yep.
There's no doubt this judge is trying to create a name for himself in the law books with this statutory change. He's trying to create case law. And there's good news to that. There's bad news to that. Let me share the bad news first. Or George, do you want the good news? It's up to you. What do you want? Good or bad?
Hit me with the bad news.
All right, we're going to go with the bad news. The bad news is Lynette can file for an injunction in the courts in Levy County before Judge Craig DeThomasis, and he can actually go, Lynette says all these people, John Smith, in her spam account, John Smith, have communicated with her because of you. Therefore, I'm going to hold you accountable, and you're going to have the consequences of that. I'm going to slap an injunction on you.
And that's exactly what he did. And Bridget is saying to Shizzy, when Jeremy went home for Ohio, after the order went into effect, seemed pepper brighten his mood. I bet it did. I mean, just about anything would. And you're asking, at what point does Randy ask him to recuse himself? Almost in every single case that he has to, where as soon as he knows who the judge is and as soon as he can get the pleading written, Randy asks the judge to recuse himself, which he does. Inexplicably, every single time, no questions asked. But as far as this case goes, I don't know, because I don't have access, because the judge sealed this case. So I don't have access to those, and I don't believe that we can even bring up those documents, even if I had them. I'm pretty positive. I wouldn't be able to tell you. And you're saying no, not during this hearing. I don't know. I don't have access to those documents. So that right there is why it's that all I can do is show what I have.
That's the bad news, that we can actually be held accountable for anybody else's actions in the world. You want the good news now?
Hit me with the good news.
We can go after everybody else in the world. So, for example, we can file suit against Shart, and we have no problem doing that, and find her and hold her accountable to all the consequences of anybody who's communicated with us, especially her, and because of her. We can go after Lynette. We can go after John Crook, because we have screenshots of every piece of communication that has indirectly come, all the threats, all the negative things, all the things that have been said, and none of this has been said by a person named John Smith.
And to my understanding, and that's why I brought it to the council's attention at the time, there's been no appellate court decision addressing that matter.
On the new statute.
Correct.
Okay.
So in that context, that's one of the many reasons, along with the other things I just said, that this case is a little different than your run-of-the-mill. I handled probably 5 or 6 other injunction cases in the previous hour before I got to this one, which took 2 hours and is now clearly going to take longer than that.
There's been 3 hearings on this case so far. And just a reminder, everything I'm showing with you is public information. 3 hearings so far, roughly 2 hours for each one, 6 hours thus far. Lynette's not even done whining, okay? So.
Oh, absolutely. And Shara has apologized to both Jeremy and George, explained herself. They both forgave her for her involvement, and she has actually provided a lot of information. If you haven't checked out Shara's page, she's given quite a bit of information in this case. Shara Michelle is her channel, or you can look up Shara Wolf and it should take you there also. But she does have a lot of information that filled in a lot of the gaps of the kind of shenanigans that were going on, and are continuing to go on with Deuce, and the behavior that he's exhibited in this. I'm sure that will be most likely be brought up in Fed Case 1, Fed Case 2. It'll be brought up in the lawsuit that he had, that both him and Jeremy are involved in the state of Florida against both Lynette and Deuce. And it's just the kind of behavior that the anti-Hales have had in all of this, and Shara's provided quite a bit of that. And there's a lot of people that still don't have a lot of love for Shara, and you're welcome to feel that way. Just know that Jeremy is moved on. He's got better things to do. You have to understand he does exhibit some forgiveness to people whenever they're making, they're like, yeah, I was wrong. He's got no qualms about, handing out that forgiveness as easy as he is to condemn. There was 3 denied recusal requests, and he finally granted writ of prohibition that removed him from the case altogether at the appeals court. Yeah, well, the appeals court is the one that went after him too, and basically pulled him out. Yeah, not only by Fleece's little PR team over there, but Char's been threatened by Deuce, has been threatened by quite a few people, and you know it's really bad, really bad. Yeah, he didn't want to look like crap on YouTube. The judge already knew what he was going to do before Jeremy even stepped into a courtroom the first time. He's going to make case law at the expense of Jeremy, right? That's what it looked like. Shara put it together, and now she's testifying. Well, she's testifying for herself. It's not just for Jeremy and George. That's part of what's being brought in, and there's certain things that she can't talk about or doesn't know. But if you've heard her deposition, we've gone over that deposition. Don't forget about the Levy County documents. It's late. Oh, I know. I haven't forgot about those. If I don't get to them today, I'll get to them tomorrow. We've got plenty of time. We got plenty of time. Like I said, it's one of those where you're looking at this and you're going, Shara has done, she's done so much investigation on this, and once she started digging into it, it wasn't because anybody forced her to do it. It was the behavior of Deuce, of Fleesa, of Lynette, and then whenever she started looking into what Jeremy was saying, she found it to be true. It wasn't true. Yeah, there is a letter. Damn it, Valley, you have to remind me of that, don't you? All right, that's what I mean. But Shara got duped big time. Yeah, and it looks like the whole ecosystem over there is blowing up. Let's see. Yeah, how about we do that? We'll go over the court documents that came in today, do the open letter, and then we'll finish up on this tomorrow. How's that? We'll do that. We'll do that for you guys. Make your life a little bit easier, so you're not just sitting here having me ramble. All right. Here we go. Let's get this document up here real quick. Oh, doggone it. Did I just close it? No, I didn't. I just minimized it. There we go. All right. Let's do that and share screen right there. Window. Boom. Bam, bam. There we are. All right. So this came in, of course, yesterday. Is that right? Yeah, day before yesterday. Day before yesterday, this was filed, and memorandum of law regarding motion for sanctions against debtor plaintiff during automatic bankruptcy stay. Basically, what this is it's addressing what the law is in this stay, because there is a stay, which usually under normal circumstances will stay the proceedings for a court hearing. Under certain bankruptcy laws, you can't issue sanctions, or in some cases you can't even have a hearing. And what Randy's bringing in here is he's bringing in the information that shows that how it applies, which is really important. By a defendant, Jeremy Hales may proceed during automatic bankruptcy stay under Florida law. And it's just basically the memorandum of law addresses a motion by a defendant, Jeremy Hales, how they may proceed to automatic bankruptcy stay under Florida law. The analysis concludes that such a motion may proceed because the automatic stay provisions of bankruptcy code apply only to actions against the debtor, not to actions brought by the debtor or defensive measures taken in response to the debtor's litigation. Now, I had to actually look this up because I was like, isn't there something? And I will tell you, Google was absolutely fucking horribly wrong, because whenever I pulled it up, it said, no, you can't do this. And then I had typed in there, and then all of a sudden it was just, I actually had to put these statutes in there. And that started changing exactly what it was saying. Yes, I did see that one. And I might cover that tomorrow, maybe. We'll see. The current case involves a situation where the debtor is the plaintiff in this state law case and is protected by an automatic bankruptcy stay. The defendant wishes to proceed with his pending motion for sanctions against the debtor plaintiff. Now, this right here, triggering an automatic stay under this one, under 362A. Now, the automatic stay provisions of the bankruptcy code are governed by 11 U.S.C. 362A, which judicial proceedings against the debtor upon the filing of a bankruptcy petition. Gives the citations. The stay is triggered automatically when a bankruptcy petition is filed, and actions taken in violation of the stay are void, even if there is no actual notice of the stay. Now, federal case holds that the automatic stay does not apply to an action brought by the debtor. However, Floridas have consistently recognized that the automatic stay provisions of 362 of the Bankruptcy Code apply only to actions brought against the debtor in bankruptcy. Federal case holds the automatic stay does not apply to an action brought by the debtor, which would be Lynette. Noting that the federal circuit courts have constantly held, relying on the language of the automatic stay provision and the policy underlying it, Section 362A1 is applicable only to actions against the debtor, not to the actions brought by the debtor. The bankruptcy courts agree. Collecting cases, emphasis in the original. Now, the language of 362 refers only to the actions against the debtor and does not relate to any inter-party claims. Also, all proceedings in a single case are not lumped together for purposes of automatic stay analysis, even if the first claim filed in the case was originally brought against the debtor. 11 USCS 362 does not necessarily stay all other claims in the case. Within the single case, some actions may be stayed, others not. And then it gives a citation of where that can be found, 1991. This means that multiple claims, multiple party litigation must be disaggregated so that particular claims, counterclaims, cross-claims, third-party claims are treated independently when determining which of the respective proceedings are subject to the bankruptcy. So basically, they separate it out in little buckets, you might say. Like you can try this, you can't try this. That's a big no-no. Now, a motion for sanctions against a debtor plaintiff is precisely the type of action that should be disaggregated from the main proceedings for purpose of automatic stay analysis. Such a motion is not an attempt to recover a pre-petition claim against the debtor, but rather a response to litigation conduct that was initiated by the debtor herself, which means this was something that she brought around upon herself. It wasn't that Jeremy filed that Jeremy created this litigation in the first place. For example, they can put a stay on any other of the other cases, because if the case was brought against her and then she has this bankruptcy stay, then all of that stuff just gets put on hold. But she is the one that brought the case against Jeremy, and he's seeking relief to get this handled. Now, when a debtor initiates litigation as a plaintiff, she cannot use the automatic stay as both a sword and a shield, pursuing its claims against others while simultaneously claiming immunity from the normal consequences of being a shithead or litigation conduct. The automatic stay is designed to protect debtors from collection actions, not to provide them with an unfair advantage in litigation that they voluntarily initiate. Like, she didn't have to bring this claim against Jeremy, but that she did. That automatic stay should not be basically, it would be like, and then saying, well, you can't throw a rock at me because, I called timeout, or I called timeout and then hit you with a rock and go, well, you can't throw a rock at me. I called timeout, and that's not fair at all. Like, and then you continue throwing rocks. Yeah, it doesn't work like that. A motion for sanctions in a defensive measure that responds to the debtor's own litigation conduct. It does not seek to pre-petition debt or exercise control over property of the bankruptcy estate. Rather, it seeks to enforce the court's rules, maintain the integrity of the judicial process. As such, it falls outside the scope of the automatic stay, which refers only to actions against the debtor and does not relate to any other inter-party claims. Conclusion: based on the foregoing analysis, a motion for sanctions against a debtor plaintiff by a defendant may proceed during an automatic bankruptcy stay under Florida law. The automatic stay provisions of the bankruptcy code apply only to actions brought against a debtor, not to actions brought defensive measures taken in response to the debtor's litigation. When a debtor initiates litigation as a plaintiff, it cannot use the automatic stay to shield itself from the consequences of assholishness or litigation conduct, including potential sanctions. Therefore, Florida law clearly establishes that the defendant in this case may proceed with a motion for sanctions against the debtor plaintiff despite the automatic bankruptcy stay. Now, this would also be the same in the trespass case, in the thumbnail case. Where they are the defendant, or where Lynette is the defendant or plaintiff, but where she's a defendant, for example, the case of Granger and Granger v. Preston, where they are the plaintiffs and she is not, that one could be put on stay. They would be able to seek any sanctions for that. So that's sort of how that one would work out. Respectfully, shock it. So there you go. There's that one there. And then, of course, there's also this one, which is quite damn humorous and sort of the basis for our little open letter tonight. Same parties. Memorandum of law regarding court's authority to hear pending motions against plaintiff and against third party Ducey while plaintiff is under bankruptcy stay. Now, this memorandum of law addresses whether this court has authority to hear and rule on a motion to strike the unauthorized communications and for sanctions for unauthorized practice of law against a third party, Ducey. While plaintiff Michelle is under automatic bankruptcy stay pursuant 11 U.S.C. 362A. Specifically, this memorandum analyzes whether the court may proceed with the motion against the third party when that motion seeks information but not monetary relief from the plaintiff protected by the automatic bankruptcy stay. Now, as demonstrated below, Florida law, federal bankruptcy principles establish this court may properly hear and decide the motion against the third party, even when the motion incidentally seeks information from the bankrupt Preston. I love that, bankrupt Preston. Provide, more like morally bankrupt. Provide certain safeguards are observed to respect the boundaries of the automatic stay. Might have a different bug. That's a possibility. Factual background: Preston is the sole plaintiff in this action who has filed for bankruptcy protection, triggering an automatic stay under 11 U.S.C. 362A. Now, Deuce is a third party, an attorney who is not licensed in this state, and who submitted himself to the jurisdiction of this court. Why? Well, by communicating to this court via several ex parte email exchanges on substantive issues, in this case on behalf of Preston. And it was, I think he thought he was getting away with it or something. Like he thought that these couldn't be brought out in court, which makes me wonder where else has he done these kind of shenanigans? One can only wonder. Now, upon information of belief, Deuce is not in bankruptcy, and therefore he's not protected by that automatic stay. And the pending motion before this court is directed primarily against Deuce, seeking an order finding that Deuce is not licensed to practice law in Florida and has not been admitted pro hoc vice in this matter. And two, that Deuce is engaged in communications with the court and parties in this case, including emails dated October 6, 2025, October 7th, 2025, and October 9th, 2025, which constitute the unauthorized practice of law in violation of the. And three, that all communications, and including emails and any legal documents sent or prepared by Deuce in this case, now you understand, you're talking about just this case, are hereby stricken from the record. And three, that Deuce is admonished for engaging in unauthorized practice of law. in Florida without proper admission to the Florida bar or pro hoc vice admission in this case. 4, that Deuce is enjoined from further communication with the court or parties until, in this case, until properly admitted pro hoc vice pursuant Rule 1.2 of the Florida Rules of General Practice in the Judicial Administration or associated with Florida counsel who actively participates in the matter, which good luck getting that. And 5, that Preston is ordered to identify the name of any non-licensed Florida attorney who drafts paperwork on her behalf, which is then submitted to the court in the future, which means that this right here, if she's ordered to identify the name of any non-licensed attorney in Florida who drafts something for her, and it's not an attorney, she has to turn over that information. She has to provide proof of who wrote that document. That's all that means right there. Right there, you must be still catching up. She nemesis. It is absolutely imperative that this right here is something that the judge will, if the judge rules on this in favor for Randy, it will calm down a lot of the bullshit that you've been seeing. That because she will be required either to hire an attorney or show that who is right, or show who is writing this for her. Like if an attorney doesn't step in, she has to show who wrote this for her. And whenever you see all these crazy pleadings that are written in there, it doesn't matter if he wrote it beforehand, because if they tell him right here that he's enjoined from further communication with the court or parties until his case is properly admitted, or he's also admonished and he's not and is also without proper admission to the Florida bar, or any communications, any legal documents sent or prepared, stricken. I mean, it's like covering all of it. And 6, that the court reserves jurisdiction while Florida attorney who drafts paper on her behalf then submitted to the court in the future, and that the court reserves jurisdiction to enforce the terms of this order and to consider any further appropriate relief, which means that the judge could fine them and actually sanction them. As part of this motion, information is also sought from Preston regarding the identity of any non-licensed Florida attorneys who drafted paperwork on her behalf, which was submitted to the court, which means she has to turn over anything that she is submitted to the court. This information is necessary to properly address the unauthorized practice of law in Florida without proper admission to the Florida bar or pro hoc vice admission in this case, which relates directly to the claims against Deuce. Like that would hit all kinds of spots right there. Yeah, that would stop anybody, including Lips or the paint chips or any of those folks that might be thinking of doing the same thing. And if she has, then sanctions would come down upon her like thunder from heaven. Either Connecticut or Massachusetts are on I don't know. They could be. I don't know. See, I don't know what's going on in Connecticut or Massachusetts. I honestly don't. Importantly, the motion does not seek monetary relief or judgment against Preston, but only information relevant to the proceedings against the non-bankrupt third party. The information requested from Preston consists of the identity of any non-licensed Florida attorney who drafted paperwork on her behalf, which was submitted to the courts, which directly relevant to determining Deuce's culpability in this matter. Basically showing that there is a conspiracy. We already know that there is, but it's coming. Preston is not objected to providing this information other than citing the protection of the automatic bankruptcy stay, and Deuce has not taken any position except for, hands on his ankles, nor has he responded since this motion was filed October 23rd, 2025. Now, no relief from the automatic stay has been sought from or granted by the bankruptcy court at this time. This court must now determine whether it can proceed with the motion against Ducey while Preston remains under bankruptcy protection, whether the request for information from Preston. As far as the summary of argument, the court has authority to hear and rule on the motion against Ducey, despite the automatic bankruptcy stay protecting Preston for three primary reasons. First, the automatic bankruptcy stay under 11 U.S.C. 362A applies only to the debtor and not to the non-debtor third parties. Florida courts have consistently held that bankruptcy stays do not affect proceedings against parties who are not in a bankruptcy, absent unusual circumstances that are not present here. Second, seeking information from the debtor under bankruptcy protection may be permissible if it does not unduly burden the debtor or interfere with bankruptcy proceedings. When information is sought primarily to advance claims against third parties. 2, does not substantially burden the debtor's reorganization efforts. 3, does not implicate property of the estate, such as requests may be permissible under Florida law. Oh, shit. Spilled the coffee on your bed. Got to change the sheet. Damn it, Valley. With Fed 1 sanctions hanging over him, he's effectively locked out of all Fed courts except his licensed state. Yes. Now, third, this court has several procedural options for handling this situation, including bifurcating the proceedings, limiting the scope of the motion, conditioning orders on bankruptcy court approval, or tailoring discovery requests to minimize any potential burden on the debtor. And see, this would have been what would have been brought up had they let the case go forward, is what his involvement is in these court cases, because in my opinion, he's been involved in a lot of these court quite some time. And in doing that, he's put himself in quite a bind. And once that proof gets out there, he is probably panicking right now. He's probably doing a little bit of hiding and not wanting to address this as he should. Instead, he's been, trying to work around the edges, causing little shit storms here and there, because he's too much of a coward to actually stand up and do the right thing as an attorney. It's not me. Be down there with that coffee. Is my audio crapping out? Wasn't the Connecticut is? Oh, this is right here in the state of Florida. All of this right here is in the state of Florida. So this has to do with Michelle's bankruptcy, has to do with the thumbnail case. I don't know about the Connecticut stuff. I believe that was already resolved, but I don't know. He did not resolve Connecticut. He did not resolve Connecticut for fear of driving across town, so naturally he moved to Massachusetts. Don't read the letter till I get back. Okay, I won't read the letter until you get back. No guarantees on that. I'm still on page 5. The automatic stay is a fundamental protection provided to debtors' bankruptcy proceedings. The automatic stay provisions the bankruptcy stays proceedings only against the debtor, not against non-debtor third parties or parties. Third parties or parties. I think that's right. Florida courts have consistently recognized that although the scope of the automatic stay under Section 362 is broad, the clear language of 362A stays sanctions only against the debtor. The language of Section 362 refers only to sanctions against the debtor, does not relate to any other inter-party claims. Now, Florida case law on the scope of the automatic stay. 1. Actions against non-debtor third parties may proceed. Florida courts have repeatedly held that bankruptcy stays do not affect proceedings against anyone not in bankruptcy. The principle cited in the Pugh was also affirmed by the Florida Supreme Court. Generally, the protections of the automatic stay do not apply to a party not in bankruptcy. Similarly, in 2018, the 3rd District held that all the scope of automatic stay under Section 362 is broad. The clear language of 362 stays actions only against a debtor. The language of Section 362 refers only to sanctions against the debtor and does not relate to any other inter-party claims. Here, the bankruptcy stay could not affect the proceedings supplementary as to notes code P&S because P&S was not a debtor under the bankruptcy code. The third-party defendants were properly impleaded based on the allegations of P&S. Oh, this will be another shit show. I plead the fifth. This is the Levy County thumbnail case. I was speaking to Chad about the Connecticut party issues. Oh, that's fine. That's fine. Disaggregation of claims within a single case. It is important to note that all proceedings in a single case are not treated as a unified whole for purposes of automatic stay analysis, even if the first claim was filed in a case was originally brought against the debtor, which is not even the case here. 362 does not necessarily stay all other claims in the case. Within a single case, some actions may be stayed, others not. Courts recognize that multiple claim and multiple party litigation must be disaggregated so that particular claims, counterclaims, cross-claims, and third-party claims are treated independently when determining which of their respective proceedings are subject to the bankruptcy stay. This means that within one case, actions against a debtor will be suspended even though closely related claims asserted by the debtor may continue. The unusual circumstances exception. I've never heard this, but we're going to find out together. The court in Butte authorizes courts to extend the automatic stay to non-corrupt co-defendants only in unusual circumstances, which unusual circumstances exist when there is such identity between the debtor and the third party that the debtor may be said to be the real party, and that a judgment against the third party will in effect be a judgment or finding against the debtor. And something like that would be, for example, if John Crook was to jump in there and start doing some shady shit like this, because he would be closely attached, then, they would have to wait until it got closed, is basically what it's saying. A critical consideration is whether the requested information constitutes property of the estate under bankruptcy law. Florida courts have recognized that automatic stay operates to enjoin a creditor from attempting to possess or exercise control of the property of a bankruptcy case. However, not all information requests necessarily implicate property of the estate, particularly when the information sought is primarily relevant to claims against third parties. The purpose behind the information request is also relevant when information is being sought primarily to advance claims against third parties rather than build a case against the debtor. Courts are more inclined to permit this discovery. The automatic stay is applicable only to actions against the debtor, not to actions brought by the debtor. This approach aligns with the principle that the automatic stay is applicable only to actions against the debtor, not to actions brought by the debtor, as in this case where the debtor is the plaintiff. I'm not going to read that because that's the same as we read it. Well, no, it's not. Federal cases hold automatic stay. It's just repeating the same thing that I showed up there. Application to the present case. Now we're getting down to page 8. So we're getting close. I hope you're back, Suit Valley. Now, in determining whether seeking information from Preston violates the automatic stay, this court should consider several factors. 1, whether the information request is directed primarily at advancing claims against Ducey rather than Preston, which means that this is all this portion right here is not going after Preston. It's not trying to attack her, bring her down, cause her grief, anything like that. It is aimed at Deuce specifically. Whether providing the information would substantially burden Preston's reorganization efforts, which means it has to do with the bankruptcy, if her efforts in this would be hindered by this, which it wouldn't. Something like that would be, for example, if he was her bankruptcy attorney, okay, then that would be something that might, burden her reorganization efforts, but he's not her bankruptcy attorney. Whether the information constitute property of the estate, which he's not related to or he has no ties to the estate. Whether the information request is merely incidental to proceedings against Ducey. And if the information request is narrowly tailored, does not substantially burden her, and is primarily relevant to the claims against Deuce, it is permissible without violating the automatic stay. This request meets all the above criteria to allow the information request to move forward. And in conclusion, based on the foregoing analysis of Florida law and federal bankruptcy principles, this court has the authority to hear and rule on the motions against Deuce despite Preston's bankruptcy stay. The automatic stay provisions of 11 U.S.C. 362A apply only to the debtor and not to the non-debtor third parties. Absent unusual circumstances, which are not present here. Moreover, the automatic stay does not apply to an action brought by the debtor, such as this case where Preston is the sole plaintiff. Florida law clearly establishes that this court may proceed with the motion against Deuce as outlined in this memorandum, respectfully submitted by none only than Shocking Law Group, Shocking Appellate LLC, attorneys for Jeremy Hales, by Randy Shocking Esquire, Florida Bar. And also service has been perfected right here, saying that on the 8th day of December 2025, a true and correct copy of the foregoing was electronically filed with the clerk of courts via the Florida Courts e-filing portal and was served pursuant to Florida Judicial Administration via the portal to Michelle Preston, pro se, at the email addresses for the same registered with the portal. So she can't turn around and say, oh, I never received it. Well, that's how you have it entered in the portal. Whenever you file this case, you set up an email address that's part of the portal. So claiming that you didn't get the information, well, that's just too bad. Look, we got the Kiwi Crypt Keeper. Thank you. I like you guys. Oh, that's awesome. The Kiwi Crypt Keeper. Good to see you. Good to see you. How you doing? All right. So is Valley back? Is Valley ready for that open letter? I mean, I hope you've got those sheets all nice and clean and you're ready to feel the pain. How about this? I've got to grab a drink of water and I'm going to give you a little bit of holiday cheer, which you can also find as one of my new videos, but I'm going to give you a little holiday cheer. And after the holiday cheer, we'll come back and we'll do the open letter. How about that? So just give me like 5 minutes and here we go.
So good when the lights all glow. Is your bargain bin Santa live from the nut show? I got my Velcro shoes and my dollar store hat. A short bus scholar with a mic and a chair. Yeah. It started with a scream and a half-broke cam. Now we're decking out the chaos like a nutty telegram. You showed up anyway, don't know what went wrong. Now you're stuck in the circus singing Shizzy's song. Mine's in the trenches with a wrench in hand, yeeting bots to the shadow band land. While I'm reading court docs like a bedtime tale, y'all still here riding the soft brand Slade affair. So here's my Christmas card wrapped in duct tape pride. From the window liquor host to the nut crew worldwide. Merry Christmas to my chat. Yeah, you beautiful weirdos. From the lurkers in the back to the day one heroes, to the mods who keep this busted sled on track. You're the reason this nut shack keeps coming back. If you're here for the drama, you're here for the laughs. You're my holiday miracle, my off-label stash. So raise a glass of whatever you got in that cup. Merry Christmas from the fool who never shuts up. Some of you pop in just to say, hey, shit, you're nuts. Then you stay 3 hours while I roast legal sluts. You tolerate my tangents and my bargain brand takes. Still type up in the chat when the internet breaks. My eyes play whack-a-mole when the trolls roll through. Finger on the trigger like not today, dude. Every time I was wrapped like a little red bow. Happy holidays, jackass, enjoy the shit show. So if you ever hit like, or you've ever hit send, you're officially part of this badly wrapped friend. Merry Christmas to my chat. Yeah, you beautiful weirdos. From the lurkers in the back to the day one heroes, from the nut who refused to bail. About the helmet and the buzzing low gear, but you carried this channel through a wild ass year. Through the late night rants and the 10-hour runs, through receipts, bankrupt clowns, and the missing brain cells funds. If there's any kind of magic in this janky little show, it's you in the chat making this dumpster glow. Oh, so here's to the replays, the sorry came late, the ones watching quiet while folding their plate, the members, the gifters, the broke but still here. You paid in attention, that's premium cheer. And march my L's with the nerves of steel. You keep the sleigh upright on a ball spare wheel. When I say something spicy and the room gets hot, you're already 2 steps ahead of the plot. If I had a fancy speech, I'd still mess it up. So I'll just raise this lukewarm coffee cup. Merry Christmas. From the chaos connoisseurs to the quiet heroes, to the moms who mop up every digital fight, you're my dysfunctional, delightful Christmas light. If you laugh face palm or yelled at the screen, you're carved in the lore of this busted machine. So from my nut shack heart to your vented device, Merry Christmas, you maniac. Thanks for being this nice. When the stream goes dark and the screen goes black, just know this nutcase is still coming back. You kept me afloat while I tripped on my shelf. Like, how did this work? Who let him stream by himself? So have a warm, loud, slightly unhinged night. May your drinks be strong and your drama stay light. And from your helmet wearing host on this Christmas delight, Merry Christmas, my people. Now go eat and go have a beautiful night.
I love it, being chased by a bear at the end of that one. And if you want to see the better resolution of that one, just go over and I have that on my channel. It's up and running. But let's go ahead and get this open letter done and out of the way just for you guys. Here we go.
It is about time. Let's break this mother down. With Shizzy, Wiz, Nut.
An open letter to the man that's hiding. Now, there's a particular kind of cowardice in the world. The kind that doesn't roar or charge or fight, but instead slithers low, damp, and conveniently out of sight, banking everything on the hope that nobody notices the trail of slime that it leaves behind. And deuce, this one's got your name tattooed on every syllable in permanent marker, you slimy, unlicensed keyboard coward piece of shit. Human lint. You have built an entire persona out of trembling behind digital curtains, firing off ex parte emails like a nervous teenager prank calling the principal's office, then sprinting back into the shadows to pretend that it never happened. You spent months strutting around like you're the puppet master of the Levy County circus, drafting garbage filings, whispering poison in Lynette's ear, firing off ex parte emails to a judge, bitch.com. You were everywhere until the second your actual name showed up on a motion for sanctions for unauthorized practice of law, then poof, gone. Vanished faster than your ethics and morals. You didn't just ghost the courtroom, you ghosted reality. You tucked your tail, zipped your lip, hid behind Lynette's bankruptcy stay like the spineless parasite you are. And oh no, poor Lynette's protected by 11 U.S.C. 362. Guess that nobody can touch her or me either. Oh, what a pathetic transparency drooling on yourself level of delusion. It is not self-sacrifice, it's not restraint, it's tactical cowardice. The stay protects the debtor, not the unlicensed clown car driver who's been steering her straight into Sanctions City. But hey, you knew that. You just hoped everyone else was too stupid to notice while you scurried back under whatever moldy rock you crawled out of. You got her out there, front and center, taking the heat for motions that scream your influence while you scurry back to whatever dimly lit corner you call a strategy room. Well, it's almost poetic how you've convinced her that this is a winning play. Her bankruptcy as your get out of jail free card when all it does is highlight your desperation. Oh, and Lynette, sweet bankrupt logic allergic Lynette, congratulations, girl. You won the gold medal in the Special Olympics of bad decisions. You let this unlicensed paint chip eating gremlin use you as a human meat shield. You let him draft your motions, feed you lines, and parade you around like a bankrupt shitbag while he hides behind your skirt. Do you think being out here waving that automatic stay like it's Excalibur, pretending it can magically slice the court's authority in half? Sure, hammer BB for practicing law without a license, but whatever you do, don't make me answer any questions or pay a dime. Well, dumbass, that's not legal strategy. That's toddler holding her breath until she turns blue because she thinks it will stop the spanking that is coming. You two deserve each other. Two walking contradictions up shit creek. One memo stays sanctions can totally proceed against a debtor plaintiff because the state only blocks sanctions against the debtor, not defensive measures. The very next memo says, but wait, we can still nail third-party BBB. Just pinky swear you won't actually collect anything from poor widow Lynette. You're not trying to have it both ways so hard you're doing legal yoga in a pretzel factory. The court isn't stupid. They see the puppet strings. They see BBB's greasy little fingerprints on every page. They see Lynette as the bankrupt sock puppet, and Deuce has his hand jammed so far up there he's tickling her tonsils. You both thought you could weaponize a bankruptcy stay the way that you weaponize everything else. Feelings, fake outrage, and the sheer stupidity of believing nobody would call you on your bullshit. Wrong. The stay isn't your invisibility cloak. It isn't your get out of consequences free card. It's a federal protection for actual debtors, not a safe space for unlicensed trolls and their enabling train wrecks. You don't get to hide behind it while trying to swing sanctions at everyone else. That's not clever. That's not strategy. That's the legal equivalent of shitting your pants and then demanding the court pretend they can't smell it. So keep hiding, Deuce. Keep letting Lynette take the public hits while you lurk in the shadows, sending your little unregistered legal carrier pigeons. Keep praying the judge buys your we can only proceed against third party, but please don't make the bankrupt plaintiff cry word salad, because every time you try this cute little dance, you just dig that hole deeper. And the court's got a front row seat to watch you both disappear into it. So enjoy the sanctions, losers. I hear they pair beautifully with bankruptcy schedules and public humiliation. Shizzy. The Velcro shoes double knotted because my laces know you two are a tripping hazard. Short bus royalty. Windows are fully licked. Crayon box empty and still smarter than both of you combined together.
It is about time. Let's break this mother down. With Shizzy, Whiz, Nut.
I don't think there was ever a canoe. they were trying, they thought that they could surf on those paddles. Another amazing letter. Well, thank you, Max Labs. Massive applause. Appreciate it. No need for applause, just throw money. No, just kidding. It is one of those that I've been getting a little bit better at it. And I do also have something else that I'm going to share a little bit with you. I haven't got it all together yet, but I've been working on a book. Now I can't show you the pages because it's not ready yet, but I can give you a little reading. I guess that's the best way of putting it. There's a little bit to this. Oh, it is called The Book of Crook. Okay. And it's something that I started working on a little while ago. And so I could read. How about I just give you the first chapter of it? How's that? Oh, a book review. This one is good. This one is good. I've been slowly working on this, and it's not quite ready because there's a few things I have to fix in there, like some spelling and stuff like that. So chapter 1, it is the first ramblings of a trailer prophet. The first ramblings of a trailer prophet, it began, as most catastrophes in rural Florida do, with the heat thick enough to chew and a man too stubborn to notice the world had given up on him. The sun hung low over the crooked trailer. Crook insisted was leaning on purpose, though the sagging blocks beneath it suggested surrender more than design. Mosquitoes orbited him like a persistent creditor. The yard buzzed with insects that had accepted long ago that Crook was not leaving, not learning, and not evolving into any meaningful direction. He stood barefoot on the patchy grass, chest puffed out as if addressing a crowd large enough to worship him. In reality, Crook was speaking to a handful of weeds, 2 bored lizards, and a stray lawn chair that had seen things it refused to discuss. With a slow ceremonial flourish, one that can only the profoundly misguided would describe as sacred, he fished a swollen notebook from his back pocket. It was warped from humidity, sticky from a wet dream he blamed on unforeseen forces, and packed with grocery lists and crude sketches he believed were prophetic symbols. He inhaled deeply, mostly swamp gas and regret, but declared to the empty yard, "I reckon the universe is listening close today." Silence followed. Crook chose to interpret it as a respectful awe. He opened the notebook to a fresh page and carved his first line with a dull pencil that squealed in protest. "A man becomes wise the moment he decides he already is." He nodded slowly, reverently, as if he had just solved hunger. A beetle ambled over his foot, and Crook accepted it as nature's applause. Confident blooming, he wrote again, "If folks don't get my wisdom, that's 'cause they weren't born at my level." And then, "Smart is what you call yourself when nobody else will." He underlined the last line so violently that the paper tore and 2 more pages fell victim to the assault. Crook believed the damage gave the scripture character. A rustle sounded from the tree line. A squirrel emerged, minding its business with the intensity only Florida squirrels command. Crook narrowed his eyes, his posture stiffening into the stance of a paranoid oracle. "They're here again," he whispered. "The Watchers." He had invented the Watchers after someone filmed him arguing with a mailbox and posted it online. Ever since, Crook believed an elite secret cabal monitored him due to his dangerous enlightenment, unaware that the only danger was him mistaking a mailbox for a rival prophet. He scribbled, "When greatness rises, shadows get nervous." The squirrel blinked at him, unimpressed, unthreatened, and wholly uninterested in joining his little cult. Oh, by the way, there are some notes from Squawky. "It ain't a camel, it's the neighbors making sure he doesn't set something on fire again. Last week he tried burning wet leaves and baptized himself with the house because he said the flames got jealous." Squawky. Well, Crook lifted his chin, announced to the open air, "There will be laws for my teaching, holy laws." He adjusted his grip on the notebook and wrote, "There are no rules except the ones I remember making later." He admired the flexibility of this foundational principle. It ensured his doctrine would never contradict itself, because any contradiction would be denied as misremembered. Moments later, struck by the urge to expand his gospel, he added, "Loyalty is proven by doing something stupid in my honor. The stupider the deed, the closer to truth you get." He slammed the notebook shut, then opened it again, then shut it decisively, as if the spiritual world needed punctuation. 3 seconds passed before he opened it once more to add, "If you smarter than me, you lying." His surge turned gray and the pencil gave out a wheezing snap. More notes from Squawky. "If y'all follow this part of your funeral, last time he demanded loyalty, 2 of his buddies tried siphoning gas with their mouths. One still talks like a ghost with a harmonica." Squawky. Seeking elevation, literal or otherwise, Crook stepped onto a lone cinder blocks he called his holy pedestal. In truth, it spared him from standing directly in an ant pile, though the ants made their intentions known anyway. He spread his arms in what he believed was a transcendent pose, but mostly demonstrated that he had once again forgotten deodorant. "Let it be known," he proclaimed to the indifferent swamp horizon, "that today marks the beginning of my prophethood." A gust of wind slapped him in the face like nature reaching for the snooze button. Crook accepted it as cosmic affirmation. He lifted the notebook triumphantly, only to fumble it, sending it tumbling into the dirt, and the ants swarmed at it instantly, crawling over his revelations with the kind of dedication no human would ever show. Crook watched, nodding sagely. "See, even nature's reading me." Nature, in truth, looked moments away from filing an injunction. The sky dimmed and the air thickened as the swamp slipped towards dusk. Crook felt the moment demand a final revelation, a signature, his closing proverb, his mark upon the cosmos. He cleared his throat and delivered his concluding line with solemnity earned by no one. "Florida man says man who thinks he's touched by greatness might just be touched by something he can't untouch." And that's the first chapter of the book of Crook. Interesting, huh? Well, so I hope you guys like that. There will be more to come, and once I get it like in PDF format, I'll show it. But till then, I think I'm going to head out. It's getting late. No, that's awesome. It's fun. It's not as good as chicken skins for the soul, but it's a work in progress. It's a work in progress. Max Labs, great chapter. Thank you. Great name. The Book of Crook. Yeah. Bravo. That's a great start. Well, thank you. I do have more chapters, but we'll go over that chapter later on, and we might just do this as a nightly story, the Book of Crook. We'll just do a new chapter every night. How's that? Everyone, have a wonderful night. I will see you guys on the flip side, and until then, be kind to one another in peace. Peace.
Oh, you thought I was done, bless your heart, but I'm still living rent-free, it's a work of art. Call me daddy, call me nut, call me the goat. You're paddling upstream while I'm running this boat. You say, I don't care, yet you're glued to the screen. Caught up in my glow while you stay unseen. Your shade's like a breeze, it's barely a draft. Meanwhile, I'm the Picasso of roasting your ass. You say you're over me, oh how cute, but here I am, still the star of your loop. You're my biggest fans, don't even deny, so grab some popcorn when daddy goes live. Call me daddy, yeah, shout it loud. King of your thoughts, I'm making you proud. Papa Nut, Shizzy, daddy, headline act. Your background noise, and that's just a fact. Let's face the score. You hate that you love me, but you keep wanting more. You're like a dog chasing cars, you don't know why. But here you are, barking while I touch the sky. Your comments are gold, such comedy gold. Who hurt you? Oh wait, it's me, I'm told. You're keeping tabs like an unpaid intern while I'm cashing checks. When will you learn? Your timeline's a shrine to every move I make. I'd say thanks, but you're a nasty skank. Oh, Shizzy's washed up. Yeah, sure, Jan, yet here I am, the centerpiece of your plan. You hate watch my stream like it's Oscar night, but guess what, kiddos? I'm still shining bright. Call me daddy. Send in your bread, I'm still rain head. Papa Nut, Shizzy, daddy on your brain. I'm your mental landlord, you can't complain. Let's
it real. You hate that I'm winning, but you love how it feels. Oh, I'm sorry, did I break your streak? You tried to ignore me for like half a week, but daddy's too spicy, you can't look away. I'm the train wreck you need every single day. So while you're out there with your plastic clout, I'm here sipping coffee watching you freak out. You're irrelevant, wow, what a take. Now go rewatch my vids while I count how much I make. Like count how much I make. Call me daddy, yeah, own it now. I'm reading your brain and you don't know how. Pop a nut, shizzy daddy, let's set the bar. I'm the constellation, you're a burned out star. Embrace your role, cause I'm the main character. You're just an old ragged ass, burned out troll. So that's your bedtime story, kids tucked in sweet and snug. Shizzy daddy's forever, you lose and you're stuck in the mud. Now say goodnight to Papa Nut, you're a mental pain. Oh wait, you will see me tomorrow's. Bitch, and will see me tomorrow, same obsession, same effing thing.